Okay, good morning to everyone. My name's Randy Otto. I'm a member of the Psychiatry faculty here at University of New Mexico. I'm celebrating my 1 year anniversary in the state of New Mexico. So happy to have been here for a year already. Time flies. This is part one of 2 days of training on forensic assessment matters for those who either have contracts with the state of New Mexico to evaluate criminal defendants around competence, or in turn contract with those persons to carry out examinations under their supervision. Just for purposes of review, we have 4 hours this Friday, and then in 2 weeks, we have another 4 hours, and that'll be delivered by my colleague and friend, Dr. Anthony Perillo. But you have me for 4 hours this morning through 1 p.m. this afternoon, and we're going to devote our 4 hours together to two topics. One is considering response style, one assessing defendants' competence to stand trial. That's what we'll start off with. And then we'll finish up with considering matters of privacy, confidentiality, and privilege when conducting competence to stand trial evaluations in the state of New Mexico. Let's see here. If we can go to the next slide, Alex. All right, Alex and I are going to take care of some housekeeping matters. And then for the first part of our time together this morning, we're going to be addressing the response style matter content, talk about a little bit about what response style is and why it's important in these contexts, discuss some interesting case law in this area. I think some of the most interesting case law that forensic examiners need to consider is in this arena. We'll talk about different types of response style, assessing response style, some clinical decision making, sort of how we weigh and make sense of information. And then I'll just let you know that at the very end of my presentation, there's a pretty extensive list of resources that'll be available for you if you want to do further reading. And pretty much anything that I cite during this morning's program, the first half of this morning's program, pretty much anything I cite will be included in that reference list, along with a whole bunch of other references for your consideration as well. We'll have a separate file and a separate discussion for the second piece of this morning's program, which again is devoted to matters of privacy, privilege, and confidentiality in the context of competence to stand trial examinations. We can go to the next slide, Alex. Okay, a few directions here. Please sign in using the chat function, providing your name and in what New Mexico districts or locales you conduct examinations. So please do that. Also, please use the chat function to ask questions or offer comments. And throughout the presentation, I'll be providing time for people to ask questions or offer comments. Brittany will be monitoring the chat function for me. I've always found it difficult to sort of focus on the presentation and at the same time monitor chat. We ask that you keep your cameras on. It makes it a little more personal. And then we'll schedule a 15-minute break, somewhere around 1 3/4 hours into the session. We'll be together for a total of 4 hours, and I think those of you seeking continuing education credits, it'll be a total of 3.75 hours we've been awarded for today's session. And then you have the follow-up session in 2 weeks. Also keep in mind that this session is being recorded as well. Okay, let's go to the next slide, Alex. Okay, this is where I turn it over to Alex, who will talk a little bit about this.
Awesome. Thanks, Randy. Hey, everybody. My name is Alex Pond. I'm an operations specialist here at the Division of Community Behavioral Health. In order to be eligible for CEUs today, you must attend the entire presentation. I'll share a link in the chat with about 5 minutes remaining of the presentation. You'll open that link, complete your CE survey, and that will automatically generate your certificate of completion. It'll also automatically send you your certificate of completion to the email that you provide in the form. Just know that you have 48 hours to complete the survey. And in order to be eligible for CEs, you must attend today's presentation in full as well as the 29th in full for a total of 7.5 CEUs. 3.75 for each presentation. If you have questions about that, feel free to reach out to me directly. I'll be here both days. So thanks, Randy.
All right. Thanks for that notice and discussion, Alex, and thanks for all your assistance in putting this together. Very much appreciated. We go to the next slide. In terms of disclosures and disclaimers, note that I will briefly reference a particular test of which I am a co-author, which means that I receive royalties. So consider yourself having been put on notice that I have a financial interest in something that I'll only make very brief reference to a little later in our time together. And also keep in mind that the views expressed in this presentation are pretty much mine. They're no one else's views. So keep that in mind as well. That's important. Let's go to the next slide, Alex. Okay, so let's get into the meat of this. What is response style and why is it important to consider when conducting competence examinations? Well, I'll say that it's important to consider when it comes to any evaluation of any person in any kind of legal context. Response style, as I describe it, refers to the conscious, intentional approach that the examinee adopts to an examination. And why is it important to consider? Because examinees' response styles have implications with respect to how accurately their presentations, and when I say presentations, I mean how they answer and respond to questions that you might present by way of clinical interview. I also consider that to include results of testing that might be administered, how accurately what they present in terms of their response to the question or their responses to test items and overall sort of test profile, how accurately their presentations reflect their actual functioning and adjustment. And careful consideration of response style is particularly important whenever examining persons who aren't participating in an examination of their own accord and may have a vested interest in gaining a particular outcome. Now, when I say persons not participating in an examination of their own accord, I certainly recognize that in many cases, a person is certainly willing to participate in the examination, but never is the examination really precipitated by the examinee himself or herself. It's always, well, the judge ordered that I participate in this examination. I'm fully willing, but the judge ordered it. It wasn't my initiation. Or my attorney said I have to participate in this examination. Or my disability insurer said I have to participate in this examination. Or the Social Security Administration said I have to participate in this examination. Now, obviously, I'm talking well beyond criminal defendants here when I mention the Social Security Disability Administration, or I reference disability insurers. So I'm talking about those forensic evaluation contexts more generally. And of course, what we're really going to focus on today is thinking about response styles when we're evaluating persons who are defendants in criminal proceedings, and there's a question about their understanding of and ability to participate in the legal process and work with counsel. Go to the next slide, Alex. Thank you. An examinee's response style can vary both within and across examinations as a function of the examination context, the goals that the examinee has, the examinee's background, and even interactions between the examinee and the examiner. That's, for example, why when we're conducting forensic evaluations, including competency and trial evaluations, we make a considerable effort to establish rapport with the person we're examining, because we want them to participate to their best. With respect to how response style can vary both within and across examinations, I'll give you a couple examples here. One of my colleagues many years ago was evaluating a personal injury plaintiff. And this personal injury plaintiff had completed whatever the current version was of the MMPI-2. And this examiner had the results of a number of those administrations. And he was looking at them, and there was incredible variability in the profiles themselves. He himself had administered an MMPI profile. He was the psychologist who had been retained by plaintiff's counsel. The psychologist retained by defense counsel had also administered an MMPI. And then somewhere along the way, the plaintiff had been involved in treatment. And what he found was in the MMPI profile that he administered and the MMPI profile administered by a treating psychologist, they were greatly elevated, very much elevated. And these MMPIs were completed close in time. The MMPI profile that was produced at the request of the defense retained psychologist was very suppressed. No indications of meaningful pathology, whereas the MMPI profiles obtained by the plaintiff retained psychologist and the treating professional very much elevated. And the examiner, the plaintiff's examiner, met again with the plaintiff, the examinee, and was trying to make sense of it. You know, he approached it, I'm trying to make sense of the test results. You were administered the same tests on multiple occasions, but with very different discrepant results. And he said, can you help me understand that? And she said, well, sure. She said, you're my psychologist. You're working for my attorney. And of course, you know, I'm confident in and I trust you. And I was very open in terms of when I responded to the multiple items. And my therapist, of course, I trust her. And I was very open again. But that defense psychologist, I don't trust him more than I could throw him. So I'm not going to share anything with him. I'm not going to share all my problems and my concerns with him. So a great example of approach to the examination varying as a function of the context and even the examiner, the person administering the test, and the nature of their relationship with the plaintiff. Another example is this. A colleague of mine was asked by Department of Children and Families in the state of Florida to evaluate a grandma who was seeking some kind of legal authority over her grandchildren because of concerns about her daughter's ability to parent. And she was referred to my colleague for evaluation. And for whatever reasons, the psychologist administered a measure of intelligence. And grandma obtained a score that placed her in the average range of functioning. And as he's interviewing her and getting her story, he realizes, I think I've seen this woman in another, I think I've seen her before. I know her from somewhere. And he just asked her, and she said, oh, yeah, I was here before, Dr. Carpenter. Social Security sent me. And he said, oh, okay, okay, that makes sense now. And he went back into his files, and he found his files on this grandma. And in that case, she was seeking disability benefits from Social Security. And for whatever reasons, he had applied a measure, he administered a measure of intelligence. So over a brief, well, maybe not so brief period of time, but over two different contexts and two different dates, he had administered a measure of intelligence to her. And he said, well, man, help me understand. When I evaluated you 12 months ago or 4 months ago, whenever it was, for Social Security, I gave you a test. You did not do so well on it. Actually, she obtained a score that placed her in the borderline range of intellectual functioning. He said, but today, I administered that test sort of without knowledge that we had this prior contact, and you did just fine on the test. Can you help me understand that? She said, well, sure, doc. And she was actually kind of surprised that he didn't get it and had to ask. Back then, I was trying to get benefits from Social Security, so I didn't want to overplay how I could do. And today here, I'm trying to convince Department of Children and Families that I would be just fine as a guardian for my grandchildren, so I'm going to do my best on your test. So different performance based on different contexts and different goals that the examinee has. And then one last example I'll give you is that you probably all have had an experience with an examinee who maybe at some point during the evaluation process gets frustrated or angry or bored or something like that, and their approach to the evaluation changes, right? Maybe they're diligently completing the MMPI and then realize, oh my God, there's 200 more questions, and then we get what looks like random responding or something like that. And all of this, along with the limitations in our assessment approaches, makes assessment of response style a very challenging issues. And then finally complicating all of this is never think that examinees are necessarily naive to what you're doing and the test you're administering or something like that. And I just give you here a link to a professionally published article that does a very nice job of laying out different kinds of response styles and different kinds of ways of assessing response style that's available in the public record. All I did was I Googled response style and malingering, Googled that. A whole bunch of things came up with Google, including a very nice AI-generated discussion of response style and its assessment and the key measures that are used. So we really shouldn't think that our examinees are necessarily naive to what we're doing or maybe tests or approaches that we may be employing. Makes this all very, very complicated and challenging. Let's go to the next slide, Alex. Some interesting things. There are phenomena along with response style that are likely important to consider in terms of an examinee's presentations, such as level of insight, as distinguished from denial. And when I use denial, I don't mean the the psychic process of lacking insight, but I mean disavowing that you have alcohol problems, disavowing that you're back to using methamphetamines or something like that. Anosognosia, which is just a fancy word for lacking insight to the fact that you do have symptoms that you do have a mental illness, as evidenced by different kinds of symptoms. And along with that, phenomena that are associated with some personality disorders and other mental disorders, and I'll just give as examples, somatic symptom disorder, illness anxiety disorder, I think a new development, a new addition in the DSM-5, and conversion disorder, which of course has a long-standing history of being recognized. I always found it interesting that although all response styles are important when we're assessing examinees or patients, there's only one response style specifically addressed in the DSM, and that is malingering. There's no Z code for active denial or disavowal of impairments that the patient or examinee knows he has. There's no Z code for identifying the person as simply denying that he's got an alcohol problem when he's fully aware that he has an alcohol problem, or actively denying that he experiences auditory hallucinations when he knows he does hear voices that aren't there and are the product of a mental disorder. And in fact, when they were revising DSM-5 many years ago, they had a public comment page where you could offer your opinions and your perspectives. I made this very point. There's many response styles that are important when we're trying to understand and make sense of the people in front of us, yet we only have one code that is dedicated to response style, that being malingering. And I pointed out that maybe there should be a code for identifying people who are denying problems that they have, whether it's with substance abuse or anything else. But that went nowhere, at least as reflected by the most recent publication of the DSM-5. And I'll also point out that the line between the response style of malingering and I would say malingering is not a disorder. I wouldn't even describe it as a diagnosis, but the response style malingering and at least two mental disorders is quite narrow. We go to the next slide, Alex. Okay, so here we have the indicators for malingering on the right side of the screen, not the criteria, but the indicators for malingering following the definition. Malingering is defined in DSM-5 as it was in prior versions of the DSM, intentional production of false or exaggerated symptoms motivated by external incentives. And the indicators of malingering have remained consistent over multiple editions of the Diagnostic and Statistical Manual of Mental Disorders. They include presentation in what's called a medico-legal context, discrepancy between claimed impairments and observations or other findings, lack of cooperation with the assessment or treatment, and then finally presence of antisocial personality disorder. And then we have two disorders in DSM: factitious disorder, presentation of self, or factitious disorder, presentation of others. In the old days, we probably would have used Munchausen's syndrome or Munchausen syndrome by proxy when maybe a parent is presenting a child as impaired. And I would just say that there's a lot of similarity here. That probably the most significant difference is that there's a reference to an absence of obvious external rewards in the factitious disorder description, but not a lot of distinction there. Let's go to the next slide. Okay. So that's that. I guess I'll take the opportunity to ask Brittany if she's found any, if there've been any questions or any comments so far, and we can address them before we get
Good morning,
before
Randy,
we
and
get
good
any
morning,
further.
everyone. This is Anita, and Brittany isn't able to make it, so I am serving as the chat monitor as well. And there is, in fact, a question. The question about participation and court-ordered nature. We tell defendants they have the right not to answer questions, yet the examiner has received feedback from TCAAs or paralegals who provide the referrals that the defendants are required to participate in an evaluation. Your thoughts?
Okay. Yeah. So, by the way, I would say that you could put refusal to answer questions, could be, relevant to making sense of response style. I think it's a complicated issue. And certainly if someone refused to answer any question, that would not, I think that would be not complying with the court order. If someone said, I'm not answering one of your questions, and you went on to question them and they didn't answer, that would not be complying with an order issued by the court, assuming the examination is court ordered, right? We can carry out these evaluations for defense attorneys without the benefit of an order from the court, in which case I think people actually do have a right not to participate in that circumstance. So I don't tell people affirmatively they have the right not to answer questions. What I do tell them is if you don't want to answer a question, rather than make up an answer, tell me you don't want to answer it. I'll tell you why I'm asking, and then maybe with my rationale or my justification, maybe you'll be willing to answer it. But at some point, I acknowledge that not answering questions turns into not participating in the evaluation. So I do see here a comment in the chat. The legal right not to answer questions was included in the sample report format that might well have slipped by. But I'm going to acknowledge it's a little more complicated. What is the court going to do? Is the court going to sanction the person for refusing to participate in the evaluation process? I've never seen it. I've never seen a person sanctioned for not participating, at least in my own practice, but we'll talk about that coming up here as well. So let's get to some of these.
I'm sorry,
cases.
Randy, I apologize for interrupting, but if I may, to the point that it was stated in the report template, that's correct. And we have actually posed that question to our legal counsel so that we can get clarification on it and then revise as needed. So a HCA legal response to that question is forthcoming.
Great. All right. Okay, and Anita, I know there's been just a couple comments here, so let's handle them before we move on.
Okay, so let's see. The next one that seems is a question. Doesn't that mean the right not to discuss something that would incriminate them? Is the first question, and then I'll let you answer that one if you don't mind.
I'm sorry, Anita, I missed that. I had trouble hearing your recitation of the comment.
Turn up my volume and see if that helps. Doesn't that mean the right not to discuss something would incriminate them?
So the person posed, does that mean that they have a right not to discuss matters that would incriminate them? I've got a couple responses to that. One is if the evaluation is ordered by the court, Estelle versus Smith, a constitutional decision, means that any incriminating they share by definition, can't be used to incriminate them. That's Estelle versus Smith. That applies in, as far as I know, all 50 states. I'll also point out that there is language in New Mexico law that says potentially incriminating information shall not be included in the report. So people may incriminate themselves when participating in the evaluation, but you know, as a function of being an examiner, that you're not to put that in the report. And you also know that New Mexico law says, and presumably, in part due to the dated decision of Estelle versus Smith, that information can't be used to incriminate the individual, to prove that they committed the offense with which they're charged. That can't be used to facilitate that. You also know that defense attorneys have the right to object if there is information that's potentially incriminating in a report. They have the right to object to that and have it excised. So there's all kinds of protections with respect to the incrimination matter, which is, it's probably discussion for a different day. But when I talk about how we go about evaluating criminal defendants' competence, I recommend that examiners ask that defendants offer their sort of perspective on what was occurring at and around the alleged offenses, with the rationale being not that I'm trying to get incriminating information, but rather I'm trying to assess as best I can their ability to discuss this very matter with counsel. Can they give a coherent account and explanation to me about where they were and what occurred and how they didn't start the fight? It was the alleged victim. That would suggest a similar ability to provide that information to defense counsel, or even testify to that effect if their case goes to trial. And with all those protections in place, Estelle versus Smith, constitutional law identified by the Supreme Court, or enunciated by the Supreme Court, and New Mexico rules about what doesn't and does go in reports, along with New Mexico law that says that when included in reports, that information is to be redacted. Lots of protections there. So the might incriminate oneself rationale really doesn't carry water. That being said, I understand why a defendant might say that. Well, Doc, my lawyer said that I shouldn't talk about anything about the offense with anyone. So, well, that's good to know. Good to know that you're listening to what your lawyer says and tells you to do. That suggests something about the lawyer-client relationship and ability to follow directions. I'll try to reassure the defendant, first of all, this is not about whether you did or didn't commit the crime. We already talked about that before we got started. This is about your ability to work with your attorney. And I'm interested in seeing whether you're able to share important information about all this with your attorney. That's all I'm asking. And let me assure you that nothing that you say about that is going in the report anyway. So maybe I can break down some of these resistance barriers and get them to comply. All right. And then there was another question or comment, Anita?
There was a follow-up to that question, and then another question, and then a few comments that I'll leave for the participants to read independently. But the follow-up to that question that was just asked is what the examinee perceives is my question. So when they state that they are not aware of protection. So when they state this, they are not aware of protection. That's the follow-up. And then I have one other question in the chat for you, Randy.
Okay. I'm getting an echo in your when you're speaking, Anita, but it might just be me. Try it again. Sorry.
Okay, let me see if I can adjust. Is that a little bit better?
It's about the same, but I'll try here.
Okay. Let me do one other question, and then I'll try to fix the audio. The other question is an important distinction, whether in the context of suspected malingering, whether there is a rather obvious potential for secondary gain versus a secondary gain that is actually stated by an evaluator. The DSM-5 TR does not specify whether the external incentive has to necessarily be articulated by an evaluator. Your thoughts? There have been attorneys have asked questions on testimony about how I would know whether they are seeking a secondary gain or
not. If I understood what you were saying, that this person commented that the diagnostic, with respect to the malingering descriptor, the DSM doesn't require that the examinee acknowledge that what they're doing is for purposes of secondary gain. No, and I think almost always that's an inference. If you're ever going to use the malingering descriptor from DSM, almost always it's an inference by the examiner that the reason they're doing it is to get Social Security disability benefits or delay prosecution or avoid prosecution. In the rare circumstance where someone says, you're absolutely right, I'm exaggerating and fabricating, and the reason I'm doing it is I was hoping that maybe these charges would go away, that's an acknowledgement that is not required. And I could probably count on one hand the number of times in my career I had an examinee who I believed met the indicators of malingering, did acknowledge that. But that being said, I think mental health professionals make inferences about people's motivations and the causes of people's behavior pretty consistently. Anything else, Anita?
No, I think there are other chats, but they're in the context of comments to be shared amongst the peers. Okay.
Well, let's move on for now, and we'll see if we can get back to some of that. I'm happy to solicit comments and questions and deal with them. Of course, I think it makes for a more valuable training experience. Let's talk about some important case law. Many of you are probably familiar with this seminal case, which is Wilson versus the United States. Many people are familiar with. Some people get confused about the holding. Again, it's not a Supreme Court case, but it does come to us from the federal courts. And the background of Mr. Wilson is that he allegedly committed a criminal act and was fleeing from the scene, was involved in a motor vehicle accident, and then sustained a significant head injury that resulted in some meaningful impairments. And the legal argument was that he was incompetent to proceed, in part because he had no memory or little memory for what occurred at and around the time of the alleged offense. And you think about capacity to assist counsel, capacity to testify. See how, if someone is truly amnestic for what occurred at and around the time of the alleged offense, it could compromise their ability to work with counsel, testify, etc. The Wilson court got this, and what they ruled was that amnesia per se is not a bar to competence. And some people mistake that to mean that if you're amnesia, you're still if you have amnesia, you're still competent. No, that's not what it is. It's really amnesia can form the basis for a finding of incompetence, but it's not an automatic finding of incompetence. That's what Wilson really stands for. And then the court goes on to identify how court should consider this issue when presented with it. The court, according to the Wilson court, is to consider a number of case-specific factors, such as how the claimed amnesia might affect the defendant's ability to testify, the degree to which the defendant's conduct around the time of the alleged offense can be otherwise constructed. Let's say, for example, the person made the mistake of trying to rob a convenience store with multiple video cameras that also had sound. The response could be, well, it's going to be really easy to recount your behavior at least during the alleged offense, maybe not before the alleged offense, maybe not after the alleged offense, but during the alleged offense, based on witnesses and the video and the audio recordings, etc. And then some other things, efforts the prosecution made to assist the defense, the strength of the state's case overall, and the ability of the defendant to get a fair trial, which seems to be ultimately the issue. I have an asterisk here about a couple of these things, including, you might want to consider, you've got a defendant who's reporting, I have limited to no memory of my behavior at and around the time of the alleged offense. It's hard for me to respond to the allegations because of my amnesia. You might talk about these issues with in your discussion of the defendant's functioning, and in your report, you might say, well, if the defendant is genuinely amnestic for what occurred at and around the time of the alleged offense, as he claims, then his ability to testify is going to be dramatically limited. His ability to offer exculpating information or explanations to defense counsel is going to be significantly limited. His ability to assist counsel in cross-examining accusers, including victims or witnesses, is going to be significantly limited. You could also maybe talk about your understanding of what other evidence is there to help the defense figure out aspects of the defendant's functioning at and around the time of the alleged offense. I will say this, in 35 years of practice, I've never had a case where the defendant's only impairment, the defendant's only problem was limited memory for what occurred at and around the time of the alleged offense, where the defendant was adjudicated incompetent to proceed. I've had cases where someone claimed they reported they had many problems, including limited memory for what occurred, and defendants were adjudicated incompetent. Never had a case where the only impairment was limited memory for what occurred at and around the time of the alleged offense, where a defendant was adjudicated incompetent. And I think that's for a couple of reasons. One is, I think we should be very modest about our ability to distinguish genuine amnesia from feigned or exaggerated amnesia. We're really quite limited in many ways, I think. That's one thing. And I think the courts share that skepticism, or they're aware of those limitations. And I think the courts fear that if amnesia for what occurred at and around the time of the alleged offense was an automatic bar to competence, they would fear a significant increase in such claims. And given mental health professionals' limited abilities to distinguish genuine from exaggerated, fabricated amnesia, I think that's where we are with this. And we'll talk more about Wilson-like cases a little later. Let's go to the next slide. A couple other cases here that are interesting. U.S. versus Bonnet and some other related similar cases that I cite for you. Both are federal cases. The appellate court affirmed the lower court's sentencing enhancements for obstruction of justice based on the assertion that the defendant feigned symptoms of mental disorder during a competence examination. So defendant does something or reports something that raises concerns about competence. Those examining the defendant opine that he was either exaggerating or fabricating impairments and ultimately was competent to proceed, gets convicted or enters into a plea agreement, and then the U.S. attorney argues in terms of sentencing, let's give him more time because he obstructed justice. He slowed down the process by making these false claims. Now, what the defense attorneys have always claimed in these cases is, first of all, you don't know. You ultimately don't know whether he was exaggerating or fabricating. The examiner might believe that, but there can be some question. And they also make the claim that if you charge people who are believed to have been exaggerating or fabricating impairment to facilitate an adjudication of competence, you're chilling defendants and defense attorneys' willingness to raise the competence issue. Sort of, hey, keep in mind, if you raise the competence issue and it's determined you were feigning or faking, you can get more of a sentence than you otherwise would. So the defense attorney concern is that maybe defense attorneys like me might not be as willing to raise the issue if raising the issue puts our clients at risk for sentencing enhancement if the examiner comes to a conclusion he was exaggerating and fabricating impairment. He wasn't incompetent to proceed. And that sort of argument, those arguments play out in each of these federal cases. And here is a sentencing enhancement for obstruction of justice at the trial level. The sentencing enhancement gets appealed, and the sentencing enhancement stands on appeal. And the sentencing enhancement was because it was determined that the defendant refused to cooperate with a court-ordered competence examination. I've never seen that. I've never seen a defendant sanctioned for not participating in a competence examination. And I think mostly for good reason, because we would never want a defendant whose refusal to cooperate, if at least partially the impact of mental disorder, you would not want to see those people sanctioned for that. For example, a defendant has a paranoid belief system that includes the judge and the examiner. And so the defendant says, I'm not participating with Dr. Otto. I'm not going to follow an order by the judge in this case. They're part of the grand conspiracy against me. I certainly would think it'd be fundamentally unfair to sanction that person who genuinely believes that there's good reason not to cooperate because of a grand conspiracy or something like that. But in this case per se, maybe the clarity around the relative lack of contribution of mental disorder contributing to this refusal, maybe it's quite clear there. So some interesting cases to consider. Any questions or comments on these cases, Anita?
No further comments. And has the audio improved a little bit, Randy?
A little better, yeah, thank you.
Okay, great.
All right, Alex, let's go to the next slide. Okay, what kinds of response styles are there? Reliable, candid, genuine, whatever you want to call that. Disavowal of impairments and negative attributes. And I'm not using the denial language there. I don't have denial because sometimes that gets confused with the psychic mechanism of lacking insight. But this is having insight into the nature of some negative impairments or negative personal attributes. You drink too much, you don't support your kids, you beat your spouse, and a denial of those negative attributes because you believe that could result in maybe a not so helpful outcome. Exaggeration or fabrication, random responding, right? Just sort of randomly answering test items or something like that, uncooperative, including oppositional, disengaged, and what Phil Resnick introduced maybe 20 years ago, this concept of false imputation, which I was clueless about until I read what he had to write about that. And false imputation, according to Resnick, is genuine impairment or symptoms that is falsely attributed to a different cause. So maybe, for example, you have symptoms of post-traumatic stress disorder that you believe, and you know as much as a examinee can know, are the result of a sexual assault. You have symptoms of post-traumatic stress disorder that you know, you believe, are the result of a sexual assault. Later in time, this person makes a claim of, let's say, sexual harassment in the workplace. I was sexually harassed in the workplace, and as a result, my emotional functioning is compromised. And they share symptoms of post-traumatic stress disorder that they've been experiencing for a long time, as resulting from the sexual harassment, and not sort of identifying these symptoms, at least in partly contributed to by the prior sexual assault. So making false claims about the cause of a genuine impairment is what Resnick, how Resnick defines false imputation. And then hybrid, which is simply more than one response style, and recognizing that someone can adopt more than one response style during the course of a particular evaluation. I think, you know, hybrid may reflect someone's maybe the most common response style, at least in forensic evaluation context. And maybe to try to make my point here, I'll invite everyone with a reasonable amount of experience to think of the person who was among the most, who made among the greatest efforts to exaggerate or fabricate impairment. Of all the people you've evaluated, one of the few that made the greatest effort to exaggerate or fabricate impairments. Get that person in your head, and I think you're going to acknowledge that that person didn't exaggerate and fabricate everything. They were straightforward in describing maybe their cognitive functioning. Maybe my memory's great. My problem solving's great. I think I'm really bright and good, and I'm going to blow the lid off your intelligence test. At the same time, I hear voices, I see things, I believe there's a conspiracy against me. They're exaggerating and fabricating some piece of the pie, whereas they're not necessarily exaggerating and fabricating all kinds of impairments across all venues or all pieces of functioning. The example I always use is this, imagine you're facing capital punishment and you're undergoing an evaluation by a mental health professional. Capital punishment, whether you get the death penalty, not an issue in New Mexico, but a subset of states it is. But whether you get the death penalty is a consideration of aggravating factors and mitigating factors. And let's say you approach the evaluation where you'll do and you'll report whatever it takes in order to avoid the death penalty. You're willing to say whatever you need to say or present however you need to present to avoid the death penalty and spend the rest of your life behind bars. I imagine you're going to exaggerate and fabricate some things. I also imagine you're going to deny and minimize some other things, right? That's a hybrid response style. And what I have here highlighted is, I think, the three response styles that, we want to probably talk about in a little more detail here. Okay. All right. Let's go to the next slide, Alex. Okay. So let's talk about defendants who might deny and minimize impairment in the competence evaluation context. Okay. I don't think this is a major issue in the competence context. I'm not saying that it doesn't occur, but I think that I'm not so concerned about it. This is my point. This is how I think about it. Happy to hear how other people think about it. If a defendant who's impaired and wants to not to disclose that impairment, doesn't want to share that impairment, can demonstrate psycholegal abilities during an in-depth examination, despite the impairments they're denying or minimizing or attempting to hide, they may well be competent to proceed. So sort of, if you're symptomatic and you have this concern that your impairments can be identified and you can be adjudicated incompetent, so you're going to do your best to minimize them and withhold them from the person carrying out the examination. If you're able to do that and convince me during the course of a comprehensive competence examination that you're competent, then maybe it is that despite your impairments that you're not willing to share, you're able to keep it together and can participate with counsel, understand and participate in the proceedings and assist counsel. So there's that. But what if the defendant denying and minimizing impairments undergoes a cursory or a superficial examination and the examiner doesn't do the due diligence that's required and comes to an opinion without adequate inquiry? Okay, we've all seen reports summarizing those examinations. If the report is not if the examination is not a comprehensive one, then someone who is able to keep it together for the cursory examination might not be able to keep it together when it comes to circumstances that essentially, as examiners, we're trying to make predictions about. It's one thing to be able to handle my questions during an interview. It's quite another thing to handle questions directed by a district or by a prosecuting attorney when you're on the witness stand. So if I, as an examiner, I don't carry out the examination that the person's entitled to, that the person should get, then I may be falsely conclude that they're able of moving forward with the process, when if I had done a more diligent examination, I might have seen some, as I refer to, I might have seen some chinks in their armor that ultimately justify an adjudication of incompetence. Okay, and what about defendants whose impairments may increase in severity between the examination? Their anxiety level, the level of their depression is not so overwhelming now that they're able to convince me they're competent to proceed. But what if over the course of their incarceration, their anxiety level increases, their the severity of their mood disorder increases? Again, if I haven't done a comprehensive examination, I'm more likely to fall victim to this, I think. Some of this might just be, well, there's going to be misses, right? There's going to be false negatives. Let's go to the next page. So, and I invite you to chime in and add on your responses to this question, but what types of defendants might disavow or minimize impairments? What type of defendants might be motivated to deny and minimize impairments they know they have in hopes of being adjudicated competent. I think in some cases, defendants with intellectual disabilities, they may be sensitive to being perceived as having lesser ability. They may be motivated to hide some of their deficits. Maybe severely depressed defendants who believe they should be punished and seek punishment. I don't want to be adjudicated incompetent. I want to pay the price for my crimes because I'm not deserving of mercy. I'm not deserving of a good defense. I'm not deserving of any of this. I just should be punished. Their thinking and how they're assessing their situation might be compromised by this mood disorder. Defendants whose anxiety and concern about their legal circumstance results in them doing whatever they can to move forward with the process. I just want to get this done and over with. Okay, I'm not really understanding things. I'm having difficulty communicating with my attorney, but my understanding is this is just going to delay the process, and I want this taken care of immediately. Sure, convict me or get me to court, but I just want to be out of this situation. I don't want any delays. Defendants concerned about a mental illness label, particularly in a correctional setting. I don't want them thinking I'm whatever the particular language is in the set of incarcerated defendants. I don't want that label in a jail. Defendants with cultural beliefs associating impairment with moral failure or other issues. From a cultural perspective, there are some peoples who, as a function of their beliefs, their culture, believe that mental illness reflects moral failure, or maybe there's a subset of people who still attribute what we would call symptoms of mental illness to possession or something like that, and they certainly don't want that. Defendants who fear being subjected to treatment or dispositions they do not want if identified as symptomatic or impaired. If I share the voices I'm hearing with the doc, if I share the grandiose beliefs I have, they're going to say I'm crazy and they're going to inject me with medicine. And that's the last thing I want. Or if I share my thoughts of suicide, they're going to put me in a turtle suit and in isolation. And I don't want that. And so that's sort of what I came up with. Recognize that there may be other kinds of motivations that might lead people to make an attempt to not to disclose some of the impairments or the symptoms they're experiencing. You can go to the next slide, Alex. When it comes to defendants minimizing or denying impairments in the competence context, what are some strategies for assessment so we don't miss these people, right? So we actually get to the level of impairment that they're experiencing. Well, I mean, sort of goes without saying, but I think a comprehensive examination where the examiner engages in due diligence. One of the concerns I have in this arena is examinations that focus more on foundational competence and less on adjudicative competence. So they focus more about assessing what the defendant knows and does not know about two things: the legal system, how it operates, the rights of a defendant, and the roles of those involved. That, of course, applies to all defendants equally. That's all the same for all defendants, is what I mean. Examinations that focus on that, and in combination with that, the defendant's knowledge and understanding of what he's charged with, what he's accused of, and what possible penalties he is looking at. And along with that focus, a relative lack of effort devoted to examining what I would call adjudicative competence issues. That is the person's ability to take all that information, weigh it, balance it, make sense of it in order to come to rational, self-interested decisions that, of course, they get to make with counsel about their legal circumstance, right? What's the weight of the evidence against me? What's a likely jury verdict or a likely, if I engage in a bench trial, what's the likely outcome versus what are the advantages of a plea agreement that might have been offered by the prosecution? I think even very impaired people can demonstrate knowledge and understanding of the former issues, adjudicative competence, and people with more subtle impairments, those more subtle impairments are more likely to show up in the adjudicative competence stuff, right? That's whether it's intellectual limitations, whether it's impairments associated with neurocognitive disorders, whether it's impairments associated with psychotic spectrum illnesses like impaired thought form, and things like that. Those impairments are to be more subtle. But my point is if I focus on asking you, what does a judge do? What does a prosecutor do? What does defense attorney do? What does guilty mean? What does not guilty mean? What's a plea agreement? How does it operate? What are you charged with? What are you accused of? What are the possible penalties you might endure? What are your rights as a criminal defendant? And I don't get to, given all of that, what are your thoughts about what you should do and how you should consider your circumstance? And what do you think it's reasonable to expect if you go to trial? And what could work to your advantage? And that's sort of, I think that's the interesting part of the competence examination, by the way. But it's always more involved and takes more effort. I think a comprehensive competence examination that gets to all of that, we're less likely to meet the people who are trying to convince us there's no impairment, I'm completely competent, doc, let me move on to the next stage, okay? I think another way to get to this is seeking collateral data with comparison of presentations with us, comparing that to the defendant's presentation in different contexts. That could be talking to jail staff if you have that ability, reviewing jail records, other collateral informants, reports summarizing prior treatments and examinations. I think about a case that I had that, if anything, this case demonstrates the knowledge and the sensitivity of the defense attorney and doesn't say great things about me, although it doesn't suggest anything embarrassing. But not too long before I left Florida to come here, I got a query from defense counsel. She said, Dr. Otto, I'd like to hire you to evaluate one of my clients. The client has already undergone an examination by a court-appointed examiner, Dr. Wilson. But I think Dr. Wilson missed it. My client is impaired in ways that clearly she didn't get to during her evaluation. And she recommended my client be adjudicated competent. So I'm stuck with that court-ordered examination. I'm willing to open up the checkbook for the Office of the Public Defender and pay you privately to evaluate my client. Let me tell you about my client. He's a young man. I think he's not so obvious in his symptoms of mental illness. He makes a great effort to hide his illness and/or he lacks insight into his illness. And I don't think Dr. Wilson did as comprehensive an inquiry as she otherwise could have. So I'd like you to take another stab at it. I'm going to have the defendant's father reach out to you to schedule the appointment. He'll be transporting the defendant to your office. And I think the defendant's father would be a great informant too about his son and how he thinks about things and how he presents generally. So I made contact with the father. The father brought the defendant into my office, and I think I uncovered a level of impairment that the previous examiner did not get to, because I think it was one of those more cursory examinations. Now, I think this really speaks to what a good job the defense attorney was doing. Nothing special about what I did, because I was clued in. I was tipped off, so to speak, by a very insightful public defender who was, appropriately advocating for her client. So in that case, the public defender herself and the father were very valuable collateral informants that Dr. Wilson simply didn't have the benefits of. And I was provided with information about the defendant's subtle impairments that made examining him quite easy. And I can't say if I had examined him without the tip-off, so to speak, and the collateral information provided by defense counsel and his father, would I have caught the more subtle impairments that led me to recommend he be adjudicated incompetent to proceed. Dr. Wilson missed it, but she didn't have the benefit of all the information that I had. So again, if I was in her circumstance, didn't talk to defense counsel, didn't talk to dad, maybe I would have been right there alongside her saying, recommending competence to proceed. Psychological testing, I'm not very optimistic about this. I'm not a big fan here. What do we have here? We have measures of personality and psychopathology with embedded measures of disavowal and denial, tools like the MMPI, the PAI. Many of you in the training are familiar with scales that they have designed to identify people either denying and minimizing impairments or trying to present themselves as having significant positive attributes that might sort of go hand in hand. There are some freestanding measures of what you might call disavowal or defensiveness, but I don't feel very good about them. But you're certainly free to come to your own conclusions. The Crowe-Marlowe scales are really, I think, more a measure of social desirability and someone who's trying to present themselves as having positive attributes than denying psychopathology or impairment they know they have. And the Palace Deception Scale, that's a typo there. It should be Palace Deception Scale. It's the old balanced inventory of desirable responding. I tried using the Palace Deception Scale in some forensic contexts and really was never satisfied with what I was getting. I'm not aware of any other freestanding measures of what you might call denial or defensiveness. If you are and you're happy with one, I encourage you to share it with the rest of the group by way of the chat. Let's go to the next. So here's a chat I just saw come up. Has there been any movement in obtaining records from MDC in a more timely manner? I don't have a response to that, Elizabeth, but I'll make sure that we give some discussion to that a little later. I'm wondering if Anita Mesa might have some knowledge about that. Anita?
We are in the early stages, Dr. Holt and Randy, about working with MDC to create a liaison that would be available to the examiners, but it's still in the very early stages that I wouldn't anticipate to have any updates probably until maybe the end of the first quarter of next fiscal year or early second quarter, so maybe August, September.
Okay. All right. I know that can be very frustrating for sure. And here's someone commenting that case managers may be able to get that kind of information. I don't know what everyone's experience is on this call, but some of the examiners here at the university have found that since changes in the law, specifically changes requiring that examiners address issues of commitment and AOT eligibility, that some of the examiners have been instructed by defense attorneys that they were not willing to work as hard to provide that kind of collateral information because they had concerns about how it might be used, specifically on the AOT and commitment issues. And there's a query here, if we're going to, what about someone who's mentally ill and by definition exaggerating? We will talk about that in this next section that's coming up. What I'd like to do is, before we move into defendants exaggerating and fabricating impairment, I'd like to see if there's any sort of lingering questions on, thinking about defendants who might be minimizing and disavowing impairments and how we might think about them. But if we don't have any more discussion in the chat, we'll move on to the second topic, which is exaggeration and fabrication of impairment. Anita, is there anything else to discuss in that way?
Sorry, I was on mute. No, I don't see anything at this time, Randy.
Okay. All right. So let's talk about sort of the flip side of the coin, identifying defendants exaggerating and fabricating impairment in competence context. I think it's likely a significant issue. And why? Because if defendants can demonstrate impaired psycholegal abilities when they actually have psycholegal abilities, they can delay prosecution. In some cases, they can avoid prosecution. They may be able to spend time in relatively better settings. It may give them access to medications that they want for reasons independent of the incompetence adjudication. And it may be a way of avoiding danger in a current setting, transfer to a different pod of the jail, placement in a single cell, not pursued by many people, but pursued by some. So I was putting together my list of, well, what types of defendants might exaggerate or fabricate impairments? Well, first of all, those who have no impairments, in which case it's by definition fabrication. If you have no impairments and you're reporting impairments, you're fabricating impairments. But what if you have impairments and you're exaggerating impairments? So I recognize that people who are ill can exaggerate or fabricate. Another way of thinking about this is that a diagnosis of a mental disorder can occur with the presence of a Z code for malingering. By definition, if you're exaggerating, you do have genuine impairment. Those seeking to delay or avoid prosecution, that might be one motivation for exaggerating or fabricating. Seeking special consideration in the jail. I'll get treatment that I otherwise wouldn't get. I'll get a medicine I otherwise wouldn't get. I'll get transferred to a different place. I'll have a different placement. One of my colleagues used to talk about gilding the lily when it came to the issue of people with impairments, maybe playing them up or exaggerating them. And this colleague had a long history in correctional settings where his point was that in some settings, you may not get treatment that you need or attention that you deserve unless you come to the attention of staff, and it's a higher bar to come to the attention of staff. So maybe you make it worse than it really is. You're genuinely in need of treatment, genuinely impaired. So you make it worse than it really is. No malevolent intent there, but it's to get treatment that is otherwise difficult to get, and which you truly need. He referred to that as gilding the lily, and I don't mean to suggest that my list is exhaustive. I'm sure there's some other kinds or types of defendants that might exaggerate or fabricate impairments as well. Happy to hear about your thoughts about that in the chat if you want to nominate some motivations for that. Let's go to the next slide. Okay. Well, what percentage of criminal defendants exaggerate or fabricate symptoms of mental disorder? That's a hard question to answer. Steve Rubenzer, who's a psychologist who's worked in a variety of jurisdictions around the United States. He was in Texas for a long time, then he was in New England. I know he's provided services in Utah and maybe Colorado, I believe. I don't know where Dr. Rubenzer is now, but he wrote a book. My recollection is right. It's something like Assessing Negative Response Style in Trial Competence Context, something like that. It's in your reference list, by the way. About a 200 to 300 page paperback. I found it very helpful in terms of learning about some of Dr. Rubenzer's thinking. So if this is a particular issue or interest of yours, you might get onto Amazon and think about that book. I have no financial interest in that book. So in this book, he summarized 18 published research studies providing estimates of feigning among defendants undergoing competence to stand trial examinations. And the estimates, the range estimates in these 18 published studies, anywhere between 5 and 35%. That's not very encouraging, right? And this variability appeared to vary with things like the setting in which the research took place. Was it a forensic hospital where people were already adjudicated incompetent, and that's why they were there? Was it a pre-adjudicatory setting like a jail where people had yet to be adjudicated incompetent to stand trial, but the issue had been raised, and also varied as a function of the criterion employed? Right? There's rarely, if ever, a gold standard. How do we ultimately know if someone is exaggerating or fabricating or denying and minimizing for that matter? Okay, but how do we ultimately know whether someone is exaggerating and fabricating? What is your criterion? Is it they admit it? You got me, Doc. I was making up all that about the voices and the little green men and all of that. I got it. Well, if it's someone acknowledging, yes, I was feigning, you were right, your suspicions were right, it's a very, very, very low base rate, okay? Rarely, if ever, do we see someone say something like that. Again, less than 5 times in my career has someone said, yes, I was exaggerating or fabricating. I'll share one or two of those stories coming up here in a little while. Is it they hit on all of the SLIC criteria? Slick, a neuropsychologist 2 years ago, published his criteria for describing an examinee as exaggerating or fabricating impairments. Is it simply, well, in my opinion, I examined him, and in my clinical opinion, he's exaggerating or fabricating? Is it using a particular test as the gold standard? Endorsing, 3 or more, or elevating 3 or 4 or 5 or more SIR scales. or below established floors on the test of memory malingering, or below chance performance on the test of memory malingering, or some classification on the validity indicator profile. What is the criterion? And important to always keep in mind is we really don't have a gold standard, and rarely do we have absolute certainty if we're going to describe someone as exaggerating or fabricating. There are false positive for sure, and there's false negatives for sure. Let's go to the next slide, Alex. What types of impairments might defendants feign in order to maybe get a desired outcome? Well, psychotic spectrum symptoms, symptoms of mood disorder, symptoms of stress disorders, cognitive impairments, right? Compromised memory, limited intellectual abilities, compromised executive functioning, impairments in attention and concentration, and then finally, general limitations in knowledge and understanding of the legal process and its operation, one's rights and one's case specifics, what you're charged with, what you're accused of, the possible penalties. And I don't mean to suggest that these are mutually exclusive. Someone can exaggerate or fabricate psychiatric symptoms. Along with that, they can exaggerate or fabricate cognitive impairments. In fact, some psychiatric disorders, some symptoms of mental illness, as distinguished from neurocognitive disorders, are partially reflected by impaired cognitive functioning as well. And certainly people can mix psychiatric symptoms that are feigned with cognitive impairments that are feigned, with feigning limitations in knowledge and understanding of the legal process. So it can be a whole host of things. Let's go to the next slide, Alex. All right. So again, this is out of Rubenzer's book. Take this with a grain of salt, and you'll quickly see why he found 73 examiners, mental health professionals, with primarily psychologists, with a fair amount of experience evaluating criminal defendants when issues of their competence to proceed with the legal process were at issue. And he surveyed them, obviously a convenient sample, about, in your experience, what to defendants who are feigning impairment, what do they do? Well, first of all, how do you know they were feigning impairment? There's the gold standard question. But again, I don't want to be too critical of Rubenzer's efforts. How did they know they were feigning? And then given that, what was your observation? What was your memory for them? And this is sort of a rank ordered here in terms of how many examiners who he surveyed endorse this. Ignorance of the legal system, limited memory for what occurred at and around the time of the alleged offense, limitations in intellectual functioning, what he characterized as other memory impairments, hallucinations, depressed mood, anxiety, as well as post-traumatic stress disorder symptoms, what he characterized as demeanor, portraying themselves as, for example, helpless, childlike, paranoid thinking, medical issues, agitation mania, disorganized speech, lack of cooperation. The only reason I pulled lack of cooperation out is I think most of the other categories in the list, are more symptom-like or condition-like. Lack of cooperation, I don't consider per se an indicator of symptom or impairment. Not that it's not important to consider in terms of this analysis, but I pulled that out for that reason. That's why it's not inserted into that list. So this is, again, the life experiences and recollections of a very select sample of reasonably experienced mental health professionals in terms of their impressions of what they've seen, for what it's worth. Let's go to the next slide. Okay. So what are some strategies for identifying defendants exaggerating or fabricating impairment in competence context? Clinical assessment sort of was what we were left with for many, many years. And then I would say maybe 50 or 60 years ago, we saw more focused efforts to assess response style in a more systematic way, specifically by testing. So for example, if you look at some of the early work of Ray, right? Ray 15 item, Ray dot counting test, some of Ray's others efforts, among the first professionals, he was among the first professionals to try to get to identifying persons exaggerating and fabricating impairments, assessing that in a more more systematic way. Pankratz was the first to sort of put together the two alternative forced choice methodology with the Portland digit recognition test, and a number of professionals sort of adopted that strategy and embedded it or used it to facilitate their own tests, myself included, with the ILK. We'll talk about that a little later. But before those efforts, it was really sort of clinical judgment. And then what had been identified by people like Resnick and others was seeing the degree to which people claimed uncommon symptoms, presented with unusual symptom combinations, demonstrated impairments below established floors. And it's interesting, right, that if you look at some of what people sort of came to and developed as a function of clinical experience in their attempts to identify people exaggerating or fabricating impairment, you see some of these strategies then get adapted in the systematic assessment, right? So, for example, you can look at some tests where there's scales that are looking for people endorsing unusual symptom combinations. You can examine tests where one of the criteria are performance on the test below established floors that have been adopted. So it's interesting how the clinical experience facilitated development for some more systematic assessment strategies. Another sort of clinical kind of approach is seeking collateral data with comparison of presentations across different contexts. And when I talk about forensic evaluation, one of the points I always try to make is that the forensic examiner can be equated to taking a snapshot of the examinee, right? In the old days, I would go to the Hillsborough County Jail in Tampa, spend a couple hours with an inmate, and I sort of equate that interaction with the defendant as a snapshot. Now, I have other data sources, right? The records that were provided, et cetera, but it's snapshot. But then there's others who are taking snapshots of the defendant in other contexts, right? They're taking snapshots of the defendant at other times. And some of these people, maybe they're not taking snapshots, in quotes, maybe they're video recording the defendant, right? Because they're seeing the person over time for extended periods of time. And I don't have the benefit of that. So for example, some jail correctional staff, they're assigned to the same unit 5 days a week, and they work 10-hour or 8-hour shifts. So they see the defendant on a regular basis for extended periods of time, and compare that to my 2-hour snapshot of the defendant. There's jail medical staff who are treating this individual, maybe meeting with them once a day if they're on some kind of special status, observation status or something like that. And then there's the jail records that include documentation of those observations, which we can look at as distinguished from interviews of maybe some of these people. There's recorded jail calls, and some of my best forensic evaluation stories are inspired by recorded jail calls. We'll talk about some of that a little later. Collateral informants, including family members, and reports and records detailing the examinee's functioning in other contexts and in other times as separate from jail records. So records of prior treatment, prior reports summarizing prior competence evaluations, et cetera, et cetera. Let's go to the next slide. So Rubenzer's book is pretty comprehensive in terms of laying out this issue of, he calls it negative response bias. I would say symptom exaggeration and fabrication specifically in the competence context. And he offers his comparison of indicative of a feigned report, exaggerated, fabricated, and indicative of a genuine report. So bogus symptoms, or I guess probably symptoms that just aren't observed among people with mental disorder, maybe highly uncommon symptoms as well. No negative symptoms with a preponderance of positive symptoms, right? So the stuff that's not so obvious. Unusual symptom combinations. Do you find that, and some of this, again, as I was suggesting earlier, some of these approaches have been adopted by test developers. So do you find that you're more likely to experience an itchiness when you're hearing voices or something like that? Slow performance, poor performance on easy items. So that's sort of performing below established floors. What's the shape of a basketball? What are the colors in the American flag as examples of that? Inconsistent performance, what's 1 and 1? What's 2 and 1? Inconsistent performance on similar tasks, and a presentation inconsistent with assessments of their overall functioning. Indicative of genuine impairment, more indicative of genuine impairment, according to Rubenzer. Impaired speech form. And Rubenzer distinguishes between impaired thought content and impaired thought form. It's a lot harder, I think, to feign impaired thought form than impaired thought content. Right? Impaired thought content, everyone's conspiring against me, I'm next on the throne to take over England. But it's harder to demonstrate that impaired thinking, which you would probably get to by how they're speaking. Disturbed affect, verbosity, neologisms, concrete thinking, poor hygiene, and impaired concentration. So someone offers some of these might present with a neurodivergent individual, but may not mean they are. Yeah, and I think, read Rubenzer. Rubenzer does not present these in any kind of way as, here's a checklist, and if they tick off 2 or 3 of these, then therefore they're feigning and they're not genuinely impaired. But certainly you have to have an understanding of what genuine impairment looks like in the various diagnostic groups or diagnostic categories. And if, I certainly think it would be worth it to talk about, what are you likely to see, disproportionately among genuinely impaired persons in a particular diagnostic group. That's certainly a thing worth talking about. And if there's things that maybe should be removed because a meaningful percentage of people in a particular diagnostic group experience those problems, and then maybe they should be removed. But I don't think Rubenzer's talking in that way. But take a look at his book and verbosity. Okay, all right. Okay, let's go to the next slide. Okay. Well, how do we go about identifying defendants exaggerating, fabricating impairment, independent of sort of clinical inquiries? There is psychological testing, measures of personality, psychopathology, and cognitive functioning with embedded measures of symptom exaggeration, fabrication. So these are not tools that are designed to assess response style specifically, but they have embedded within them items that can be examined, or scales that can be examined to identify efforts. So, within the CBLT, one of the, there are the forced choice inquiries as an example. The MMPI-3 and the PAI, both measures of psychopathology and personality, have embedded within them a variety of scales designed to identify people exaggerating, fabricating impairments, as well as disavowing impairments. And then there's a whole host of freestanding measure, what I call freestanding measures of response style. Things like the MFAST and the SIRS-2, designed to, I would say, identify people exaggerating, fabricating psychotic spectrum symptoms. A number of tests that have been developed to identify people identifying either memory impairments or limitations in intellectual functioning, specifically the VIP there. And then we have at least 3 measures designed specifically to identify people feigning limitations in their knowledge about and understanding of the legal process. The inventory of legal knowledge, that's one I co-authored, for which I receive royalties. Keep that in mind. The test of malingered incompetence, developer's name escapes me. Apologize for that. Not commercially published. And then Bob Denny, his name may sound familiar to some of you at least. Denny would identify himself, I think, as a forensic neuropsychologist, and he had a long career in the Federal Bureau of Prisons at the Federal Medical Center, the Medical Center for Federal Prisoners in Springfield, Missouri. And during his time there, and since he retired and continues to practice actively, independently, Denny had a very accomplished career contributing to the academic literature. So just within the past year, Dr. Denny developed a really interesting measure that not only includes a 2 alternative forced choice approach, so the person answers a number of items that Kevin Caldwell, thank you, Jason. Kevin Caldwell is the developer of the Tommy. Denny's approach, really interesting. And by the way, the article referencing his new approach is in your reference section. But Denny's approach not only includes 2 alternative forced choice approach. So a number of items where they have two choices, they have to endorse one. So you've got a floor approach there. You also have a below chance performance, but, and this should not come as a surprise because my explanation is because Denny spent a lot of time in Springfield, Missouri, working with a guy by the name of Rick Frederick. He also adopted a performance mean approach, right? So there's, I think, 90 plus or minus items on the Denny tool, and they vary in level of difficulty. And much like you get a performance curve analysis with the VIP, because the items on the VIP, the two subscales of the VIP, vary in difficulty, you can compare running means. So if you understand what I'm talking about, you understand what I'm talking about. If you don't understand what I'm talking about, you might want to orient yourself to the VIP. You might want to orient yourself to Denny's approach, which is very much, takes after the VIP. Shouldn't be surprised to learn that Bob Denny and Rick Frederick overlapped a fair amount of time at that federal facility in Springfield, Missouri. By the way, all of those asterisks indicate that the test employs, among other things perhaps, a two alternative force choice approach where you can look for below floor performance as well as less than chance performance. Again, I suspect that not everyone in the training, I suspect this may not be making sense to everyone. That's okay. And if you want to learn more, then pursue, I would specifically look at the VIP and Denny's tool because their approaches are identical, I think. I will point out that Denny's approach is compared to the Tommy and the ILK. It's a paper and pencil measure, so the person has to be literate. They have to be able to read, and they have to be able to read English. But of course, have to be able to understand English is not specific to the Denny. The other two tools there, the ILK and the Tommy, too. That's the case. But you don't need to be literate for the ILK or Tommy. You do need to be literate for the Denny. Okay, let's go to the next slide. Okay, so let's think about if you were going to use tests to identify people exaggerating or fabricating impairments. Of course, you always have the normative issues, right? Because we should be thinking about that when we select any test. On what population was this normed? And given the population on which this was normed, is it fair to administer this test to this particular examinee? Does he or she have enough in common with the norming group, or are there differences between important differences between the examinee's background and life experience or language and that kind of stuff and the normative group that it's just not appropriate to use the test? Another thing I encourage you to think about is I think it makes little sense to administer tests that are focused on identifying persons feigning X-like symptoms if they're only reporting Y-like symptoms. So if someone is presenting as the poster child for someone whose trial competence is compromised by severe, overwhelming symptoms of depression, that's their only impairment. I don't know if it makes sense to use certain tools with them. Or if someone is saying, my only problem is memory problems. My only problem is memory problems. My memory for what occurred at the time of the offense is a problem. My remembering things currently and in current life is a problem. I don't know if it makes sense to administer a tool designed to identify people feigning psychotic spectrum symptoms. But maybe you want to administer a tool designed to identify people feigning memory impairments. Similarly, if someone says, My only problem are these voices and these beliefs I have about people working against me. My memory's fine. Why administer a tool designed to identify people experiencing memory impairment, feigning memory impairment? Just doesn't make sense conceptually to me. We always have to consider the tool's demonstrated sensitivity and specificity, as this has implications for how we use the test and interpret findings. I once had a colleague say, you know, my favorite test of response style is the Ray 15 item. The Ray 15 item. And I said, well, you know, there's real concerns about the sensitivity of this tool, particularly depending on the cutoff. He said, yeah, of course I know that. I know that it's not a very sensitive tool, but if you use the appropriate cutoff, it's free and it takes a couple minutes. That's why it's my favorite tool, right? If someone gets a qualifying score with the appropriate cutoff, I'm pretty confident that they're feigning some kind of impairment. But if they get a good score on that tool, if they get a score of 13, I'm not going to make much of that, right? I'm not going to say that's compelling evidence. So, you know, think about sensitivity versus specificity. Think about, you know, what does the test take in terms of time and cost and effort and all of that. Go to the next slide. We don't have, not that you thought we did before today's program, but there's no clinical conclusions or tests that are without false positives or false negatives, okay? And we likely have no data regarding error rates for clinically based conclusions, right? Because I don't know where that research is, right? Dr. Otto and get a bunch of other people to form opinions about people, whether people are exaggerating or fabricating impairment based on my clinical impressions. Do they endorse bogus symptoms? Do they get really simple challenges incorrect, like they say a basketball is square? You know, they say a quarter's worth less than a penny, whatever. I don't know where that research is talking about the accuracy of conclusions. On the other hand, you know, we should have, at least with commercially published tests, we should have some insight to false positive, false negatives, error rates, etc. That of course vary as a function of a number of things, including base rates of the condition and the population in which you're applying the tool, whatever. False positives and false negatives come with high stakes, right? Saying someone is exaggerating and fabricating, that's often that often follows them around, and particularly if it's inaccurate, they're genuinely impaired, and they're adjudicated as competent because the belief is that any impairments they're demonstrating are feigned. That's a terrible thing, to go through the criminal justice process truly impaired and unable to meaningfully participate and consult with counsel. And false negatives come with high stakes too, right? That someone is identified wrongly in the other direction. Think about communicating varying levels of confidence depending on the type of evidence you have. So for example, in some of these two alternative forced choice measures, if someone gets a score significantly below chance, what's the explanation for that? Tell me what the explanation is. When you can calculate the probability of getting such a low score, similar to the defendants, if one was simply responding randomly, that might give you a higher level of confidence than if they simply scored below the established floor, right? Performing below, significantly below chance is different than performing significantly below the established floor, okay? Or think about other kinds of evidence, right? We'll talk about other kinds of evidence. including what someone said or how someone performed in a recorded jail call as evidence, as example. Let's go to the next slide. If you are using tests, carefully consider how you describe them and in what kind of detail, both in written reports and testimony. Keep in mind, for example, test security concerns. We can talk about test results, scale, scores, how someone performed on a particular scale without giving away the strategy or the approach to testing. There are no tests of malingering. And I'm surprised by how frequently I hear this, right? That people say, oh, I administered 2 measures of malingering. There's really no, technically, there's no tests of malingering. There's tests designed to identify people who are exaggerating or fabricating impairments. I agree with that. But malingering is that plus. Malingering is that plus, and almost always, an inference that the motivation for the performance is some kind of external incentive, right? And I'm not saying you can't make an inference about the external incentive, but you have to acknowledge it's an inference, and you don't want to misrepresent a measure of response style as you measure malingering. We don't have any tests that gives us why someone, the motive for this approach. And we're stuck with inference, absence other compelling data, which we'll talk about a little later. Keep in mind you're offering expert opinions about response style, not expert opinions about the examinee's veracity. And I laughed as I was reviewing this presentation yesterday. I've got a pending case in Tampa, and a silly case, really. So it's a criminal case. The defendant is charged with, in Florida, it's lewd and lascivious behavior. And basically, he's accused of fondling his stepdaughter when she was about 11. And 4 or 5 years later, she comes forward and says, this was a secret for 4 or 5 years, but my stepdad, touched me between my legs for some period of time on one occasion. And she comes forward. This stepdad is now out of the family. There was a divorce, not because of any allegations of sexual misconduct, but her mother, subsequent to this reported event, divorced this man, the stepdad. And so they contact law enforcement, and law enforcement gets the stepdaughter, who's now 15, 16, to do a controlled call, right? So there's a deputy with her. She calls up the stepdad. I need to talk to you about what happened in the garage or in the living room that day. My therapist is asking questions, and it's really affecting me. And, you hurt me that day, and what you did was wrong. And I need you to admit it, to say that will help me. And obviously they're trying to get an admission recorded that they can use to facilitate a prosecution. So this guy dances around. He says, I never meant to do anything to hurt you. I always felt positively about you. And if I ever did anything that hurt you, I apologize for it. But he doesn't say, you're right, I should have never touched you between your legs or anything like that. So in any case, they're going forward with the prosecution. The defendant was examined by a forensic psychiatrist who, among other things, administered a number of measures, including the psychopathic personality inventory, the MMPI-2, which I rekindled my memory. That was developed in 1984, 1985. another couple tests. And among the things that the psychiatrist testified to in deposition, we have a very rich deposition process in Florida, even in criminal cases. Testified that he interviewed the defendant extensively. The defendant outright denied any kind of inappropriate sexual contact. And the psychiatrist had no reason to believe that he was lying because of the defendant's performance on the MMPI-2. So the MMPI-2 lets me know he wasn't lying, including when he denied the inappropriate sexual contact with his stepdaughter. So you can imagine the prosecutors, not a particular fan of this, tried to exclude the psychiatrist's testimony using a Daubert challenge, but was unsuccessful. And then, as a result, hired me to rebut the psychiatrist's testimony about forming opinions about the veracity or the truth-telling of the defendant based on validity scales of the MMPI. So we're not really talking about whether someone's telling the truth or something like that. Keep in mind, feigning and true impairment are not mutually exclusive. So someone who's impaired can exaggerate. By definition, if you're exaggerating, you have some level of impairment. And sometimes you might be stuck saying, I'm not sure. I'm convinced this person is impaired. I'm also of the opinion that they're exaggerating some of their impairments, and what their genuine abilities are, I don't feel like I have a factual basis for offering that opinion specifically. And I think in all cases, we have to be candid about our abilities, including limited abilities, when communicating any of this with the decision maker. Let's go to the next slide.
Excuse me, Randy, there's a question if I could pass it along. Would that be okay?
Yeah, sure. Go ahead, Anita.
So when defense asks for raw data, what is our response? In the private practice world, I only turn over raw data to another evaluator.
I'll just say this quickly, that there's a number of places you can go for guidance. So, for example, the American Academy of Clinical Neuropsychology, the National Academy of Neuropsychology, and the American Psychological Association have all offered guidance on how to respond to those requests. And that's where I'd start you. I don't feel like I can talk at length about that given where we are time-wise, but that's where I would direct you to go. In National Academy of Neuropsychology, they have a couple statements on test security and turning over the clinical record to attorneys, National Academy of Clinical Neuropsychology, American Academy of Clinical Neuropsychology, and APA as well. I'm aware of those, but does the court have the right to raw data? I hope this clarifies. I don't know if the question is the court. Well, maybe when you say the court, you probably mean the attorneys. It depends on who you're asking, and it depends on the jurisdiction. Organized neuropsychology has made some real effort to protect these kinds of data from parties, including attorneys. They've met with some success in some jurisdictions. They've met without some success in some other jurisdictions. So I think it depends on the jurisdiction. It depends on what's being sought. For example, test data versus test materials. That's one distinction. In addition, notes describing interview interactions. So again, it's unfortunately more complicated than I can get to here. Let's take, we've been going for 2 hours. Let's take a 15-minute break. We'll come back and finish this discussion, and then we'll get into the second part of today's session. So let's take a break until 20 minutes after the hour, okay? Maybe we're thinking that their unwillingness to participate in the examination might involve matters potentially involving feigning or not. If we're going to opine about persons not examined, there's all kinds of documents and caveats that apply, right? First of all, we have to document any reasonable efforts to examine, right? They were offered an opportunity, they were offered an invitation to participate in an examination, and they refused. We might be able to offer some opinions about someone even without examining them, although I think everyone realizes that the number of opinions we can offer about someone without the benefit of an examination is considerably more limited. And then finally, there's got to be an affirmative disclosure that there was a lack of an examination. Presumably, there'd be reference to the efforts, the reasonable efforts made, and the person's responses, and any associated limitations that follow as a result of the failure to have personal interaction and contact with the examinee, or in this case, defendant. I highlighted on what I believe is the next slide, the specific section of the Ethics Code for the American Psychological Association, if you can get to that, Alex. So, one, psychologists base opinions contained in their recommendations, reports, and statements, including testimony and legal proceedings, on information and techniques sufficient to substantiate their findings. So the general rule is that we have to have an adequate factual basis for any opinions we offer. There's a general rule that psychologists only opine about the psychological characteristics of people after having conducted an examination adequate to support their statements or conclusions. But there is a recognition that there may be some circumstances where an examination is not practical, is the language. The psychologist documents the efforts they made, the results of those efforts, clarifies the impact of the limited information on their opinions, and they appropriately limit the nature and extent of their conclusions or recommendations. In my experience, I remember the times going to a jail, reviewing a jail medical record that described the person as terribly impaired, engaging in all kinds of problematic behaviors, exhibiting all kinds of symptoms of severe and persistent mental illness. And then I'm told, well, you're certainly welcome to make an effort to examine this person, but they're so impaired, I can't believe they're going to be cooperative. And I've had those experiences where I've had the opportunity to review, to observe what I thought was a very, very obviously sick person who's so sick they, among other things, they're not able or willing to participate in the evaluation. I've written those reports where I'm offering opinions about their impairments, how those impairments affect their ability to participate in the legal process, et cetera, with all of these caveats, here, of course. Let's go to the next page, Alex. Did we skip anything, or this is the next page? Yeah, okay, okay. I'll just talk about a case example or two, and then we'll move on to the next, to the discussion of privacy matters. The last one here, 35-year-old Hispanic male facing charges of possession and distribution of a controlled substance. He got caught. Well, the allegations are he got caught with a lot of heroin at the Tampa airport. And it was interestingly a state prosecution, not a federal prosecution. Something like that could get the attention of the feds, but for whatever reasons, it was state of Florida. And he was presenting as terribly impaired in the jail. Like most jails, Hillsborough County Jail routinely recorded inmate-initiated phone calls, and the prosecutor provided me with a selection. Well, I guess all the calls, not a hand-selected few, but a large number of calls that the defendant made to his father, talking about how he thought he almost had everyone convinced that he was mentally ill, and if he can get a competence adjudication, he can, worst case scenario, delay prosecution, possibly avoid prosecution altogether. But he's got him thinking that he's intellectual, his words, mentally retarded and can't do anything. And if he gets any kind of contact from anyone affiliated with the legal process, he as his father needs to sort of stick with the story. That was one of my interesting cases. I had a 14-year-old teenager in juvenile court facing burglary and grand theft charges, who was presenting with what I thought clinically was impairments in his understanding of an ability to participate in the legal process that wasn't genuine. I administered the inventory of legal knowledge to him. I got to keep in mind, right, that tool was never normed on juveniles, but I administered it to him nonetheless, thinking, well, if I get less than chance performance, I'm willing to interpret those results, less than chance. But I didn't get less than chance performance. I got below established floor performance. But of course, you're comparing him to adults. But I did not get less than chance. So the public defender called me up and said, well, Dr. Otto, where's your report? What are you going to do here? I said, look, I'm going to just be straight. I have genuine concerns about how he's approaching the examination. But I don't have enough evidence to say that his impairments are not. The best I could say is that there's exaggeration of genuine impairment here. But I reluctantly, I'm going to recommend he be adjudicated incompetent in an abundance of caution. And so the report's forthcoming. But, I just thought there's some evidence, but not enough. So that's a take-home point, a learning point, I guess. And then she called me back 2 days later. Dr. Otto, you were right. I said, well, what do you mean I was right? Well, I went, I just met with my client, the 14-year-old, and I told him what you told me, and he freaked out. And he is afraid he's going to be adjudicated incompetent and sent to the residential restoration program, which is in the panhandle of Florida. This doesn't help. It's in an area called Tate's Hell, Hell, very remote area of the Florida Panhandle, and he is begging for reevaluation because he realizes what he's gotten himself into, or may have gotten himself into. So he came into my office a few days later, and on the inventory of legal knowledge, he obtained a score something like 40 out of 61 items. The first go round, better than chance, less than the established floor, but not normed on juveniles. I gave him the inventory of legal knowledge. The second administration, 61 out of 61. What a great change there. So I sort of coincidentally, or luckily, had my initial suspicions confirmed. And the last story I'll give you is a 38-year-old white male facing federal charges of solicitation, possession, and distribution of child pornography. He had already been evaluated by a defense-retained psychologist and psychiatrist who noted medical records indicating a history of stroke, and they both reported that the defendant shared with them a very limited understanding and knowledge of the legal process and the basis for his current involvement. And their description of the defendant I found sort of inconsistent with his living situation otherwise. That is, he was living independently on disability benefits, admittedly, but living independently and apparently meeting all, if not most, of his sort of basic needs without any kind of assistance. So I was evaluating him, and again, I thought I had performance indicative of feigned impairment, not knowing who his attorney was, not knowing what a defense attorney did, that those deficits, the severity of those deficits, not knowing what guilty meant and not guilty, a plea agreement and things like that. But I did have some testing. I did have some testing on measures of memory and intellectual functioning and corresponding measures of response style that suggested exaggerated impairment. But I asked the state attorney to get the, the U.S. attorney, federal case, to get the jail recordings. And this was more than I could ever ask, which was they got the recordings for the days that I had met with the defendant. So I had all kinds of recordings, but not only did I have recordings generally, but the days that he met with me. He spoke with his mother every day, where he's referencing the evaluation process and the need to involve defense counsel because of concerns about my evaluation. So this is a guy who didn't know what a defense attorney was, didn't know who his defense attorney was, yet literally hours later was sharing with his mother that the name of his defense attorney, and that they needed to talk about this court initiated competence evaluation and this examiner working for the court because of concerns that he had. So that was some of my more interesting case experiences in this area. We go to the next slide, I think. All right, so we don't need to talk about the references. There's a lot of them for the interested reader. And I think you might go to the very end, Alex, and I hope that might even be the correct QR code at the end. Or you can just put it up, Alex.
I'll drop it in the link or in the chat as well. Yeah.
Okay.
Thanks.
So you're going to put that, can you sort of orient people as to what they need to do with that link, Alex?
Okay, perfect. So I dropped the link in the chat now for your CEs. Go ahead and open that form and complete the CE survey. Your certificate will be automatically generated and it'll also be automatically sent to the email that you provide in the form.
Okay. Are you advising they do that now, Alex?
They should do that within 48 hours.
Okay. Do they have to save that so that they can go back to it then?
Yeah, they can either grab it from the chat now and save it, or they can access it in the chat in the next hour and a half.
Okay. All right, good.
Thanks.
Okay, while they're doing that, you might drop the current presentation and load the second one.
Perfect. I'll do that now.
Great. Thank you. Some of you, I believe you were provided copies of the PowerPoint file I used. Some of you who are more detail-oriented might have recognized some differences between what you were provided and what I employed. If you email me, and my email address is on the first page of that presentation. I'm happy to give you the tweaked or updated copy. Happy to send that to you if that makes a difference. Happy to do that. Okay, and let's get to our second topic for this morning. This topic actually was developed in response to a number of questions that examiners had presented to administration, state administrators about some of these concerns and issues. So I took the opportunity to put this together in anticipation of today's training. So it's titled Privacy, Confidentiality, and Privilege Obligations Impacting Criminal Competence Examinations in New Mexico. So let's go to the next slide. Okay, we got some housekeeping stuff again. Then we'll get to the meat of things, talk about some definitions and distinctions when it comes to privacy, confidentiality, and privilege. We'll talk about confidentiality and its limitations in detail in the state of New Mexico, privilege and its limitations in detail in the state of New Mexico, some related matters that we actually spent some time earlier this morning talking about, and then some key takeaway points. So let's move on. Okay, I have no financial interest related to the content that I'm presenting here. And of course, as always, these are my views. They're not anyone else's views or positions. Go to the next slide. Okay, privacy. As I think about privacy, it's a very broad and general term, and I would fold in confidentiality and privilege under a more general umbrella of privacy. And I got some sort of standard dictionary definitions about privacy and came up with something I sort of blended as the right of individuals to control access to their person or information about themselves, the ability to determine what personal information is shared, with whom, how it's used, often described as the right to be free from unwanted intrusion and to have control over personal information. I think that general descriptor of privacy sort of gets to much of the spirit of confidentiality, the rationale for confidentiality, and the spirit and rationale for privilege. Let's go to the next slide. Confidentiality, I start by describing it not only as an ethical obligation, but a legal obligation to keep information shared by service recipients private. I cannot identify an ethics code, medicine, nursing, social work, American Counseling Association, psychology. I don't think you can find an ethics code for healthcare professionals that doesn't reference an obligation to keep what people who receive services from the professional confidential and private in some way. But it's also a legal obligation in that I think you'd be hard pressed to identify any practice act for any healthcare profession or discipline. Again, nursing, medicine, social work, psychology, professional counselors. I don't think you'd find a practice act for any of those disciplines or professions that doesn't legally obligate the professional to provide some level of privacy by way of confidentiality. Always with exceptions, but the general obligation nonetheless. So when I was teaching ethics courses back at one of my old universities, USF, University of South Florida, I would tell students that if you violate confidentiality, that you share information inappropriately without, indicated exception, not only are you likely violating the ethics code under which you operate, but also the Practice Act under which you're licensed. Okay. But there's always limitations, right? And you'll see there's both limitations to confidentiality, many of which you're familiar with, as well as limitations to privilege, too. You might be less familiar, but we'll see. Go to the next slide. Okay. Common exceptions to mental health professionals' duty of confidentiality. There's waiver, and I have waiver in parentheses because if someone's waiving confidentiality, you're not breaching confidentiality. A waiver is an invitation to share what would otherwise be confidential with someone else. Please bring in my spouse and talk to her about my conditions and how she can do a better job of responding or something like that. Or please share, your impressions of my condition and how it qualifies me for an emotional support animal that makes me eligible for housing that I otherwise would be ineligible for because they have a rule against pets. There's an example of that. Or please share some discussion of my impairments and how my employer might need to make reasonable accommodations in my work schedule or expectations of, my work and that. Invitations to share what would otherwise be confidential information in certain contexts. There's the waiver, but I don't really, I don't consider waiver a breach per se. Another exception that we often see is duty to protect clients or patients, depending on your language, and third parties from harm. Okay, that is a genuine breach when it's done without permission or agreement by the patient client. Reporting suspected abuse, neglect, exploitation of what I call vulnerable populations. That's the language I use. Children, they're vulnerable because they're not a majority and there's all kinds of things they can't do in their own self-interest, and they're subject to control by others whose abuse or neglect may be problematic. Not all adults, but vulnerable adults who are vulnerable or impaired and unable, maybe conceptually, I think about it as similar to children, not identical, but similar in that they may not be able to, as a function of their vulnerability, protect themselves from abuse, neglect, or exploitation like non-vulnerable adults can. And then finally, in a minority of states, patients. I don't believe New Mexico is such a state, but I will alert you to this fact. It might be 10 states right now, somewhere in that neighborhood. 10 states obligate healthcare professionals to breach confidentiality to report allegations of sexual misconduct by other healthcare professionals. Florida, where I came from, is a great example. The example I always use is you're providing therapeutic services to Ms. Jackson, and Ms. Jackson says, well, doctor, I used to be treated by a practitioner here in town. You might know him. His name is Dr. Swenson. And a bell goes off. Sure, I know Swenson. He's another licensed whatever in town, licensed social worker, licensed professional counselor, licensed psychologist, physician. And I stopped treatment with him when I realized we should not have been having a sexual relationship. You've just received an allegation of sexual misconduct by another healthcare professional. It was sexual contact that occurred during the course of treatment in Florida. That is sexual misconduct that is criminal. And Florida requires the healthcare professional receiving the report to reach out to the board that holds the license of the accused healthcare professional and make the report without the consent of and over the objection of the patient who made the allegation. Uncommon, I think, because of concerns that this reporting might sort of be doubly victimized by the first healthcare professional engaged in the sexual misconduct, and now confidentiality being breached by the reporting healthcare professional. So this is not a requirement, a population that's really gained a lot of momentum in terms of changes in state laws. I think Colorado might be such a state as well. I'm not sure about that, but Colorado might be as well. I just want to make an important distinction. Well, I think it's important. You might not see it as important, but if you look at the last two bullets, or the last two major bullets here, duty to protect clients, patients, or third parties from harm, suspected abuse, neglect, exploitation of vulnerable populations. My language, by the way. They're really, I think it's different to appreciate a difference here, and that is in the former, duty to protect clients, patients, whatever language you use, or third parties from harm. The reporting is to prevent a feared outcome. You're making a prediction, and the reporting, I think the rationale is to prevent a feared outcome. Someone harming themselves, maybe, in an effort to die by suicide, or harm others seriously. In the second category, though, these are reports of what we believe to have already occurred. Right? We believe that a bad act, a bad outcome occurred, which is the abuse or neglect or exploitation of a child or a vulnerable adult, in a minority of jurisdictions, a patient of a healthcare professional. And it's a response to an event that is suspected to have already occurred, as to an event that has not yet occurred, but the breach is designed to prevent it. I assume that we believe that reporting suspected abuse or children, vulnerable adults, is partly motivated to prevent more, but it's also a response to an act that is believed to have already occurred. So similar, but different in that way, at least. Let's go to the next page. All right, so let's talk about confidentiality. We know that there's a general obligation for all healthcare professionals to keep communications confidential generally, but there are exceptions. And I'm going to focus on the Psychology Practice Act here in New Mexico, okay? This is taken from that act. There's going to be similar language. I can't promise it's identical for persons who hold similar kinds of licenses. Informed consent for therapy and evaluation. The psychologist shall appropriately document and obtain appropriate informed consent for therapy or related procedures or evaluation. And I would argue that the evaluations that we're all here to discuss would qualify under that rubric. Informed consent means that the person has the capacity to consent, obviously, has been informed of significant information concerning the therapy or evaluation in language that is understandable, emphasis added. That's my emphasis, and I'm just inviting you to think about, what you're sharing with the people you're examining, and then has freely and without undue influence expressed consent. This is a very common definition of informed consent. 1, you're capable. 2, there's no coercion. And 3, you've been provided with the kind of information that is reasonable to expect when trying to make a decision about whether you want services or participate in the proposed service, whether it's intervention or assessment. Another important discussion here: when persons are legally incapable of giving informed consent, the psychologist shall obtain informed consent from a legally authorized person if such substitute consent is permitted by law. This, of course, is referencing the most common circumstance when guardians, typically parents, consent on behalf of services, consent to services on behalf of their children. But it could also occur in other guardianship contexts and circumstances like that. Go to the next page. There's a continuation. Informed consent for therapy and evaluation. In addition, the psychologist shall inform those persons who are legally incapable of giving informed consent about the proposed interventions or evaluations in a manner commensurate with their capacities. This is really, I would say, a reference to seeking assent from persons who don't have capacity, seeking assent from persons who don't have capacity, like a child or like someone who's lost the right to consent by way of a guardianship proceeding or something like that, seeking or obtaining their assent and considering their person's preferences and best interests. Let's continue with this discussion. Discussing the limits of confidentiality. The psychologist shall discuss with persons and organizations with whom the psychologist establishes a relationship the relevant limitations on confidentiality, including limitations where applicable in group marital and family therapy, and the foreseeable uses of information generated through his services. I just wanted to let you know that wasn't my sexist language. That was the sexist language of your state legislators. So you can see this, by the way, is in italics. This is my own emphasis added here as well. The foreseeable uses of the information generated through services. So what it got me to thinking about was, with changes in New Mexico's law a year or so ago, there's probably additional disclosures that we want to make regarding how this information could be used in a commitment hearing, or how this information could be used in a hearing regarding assisted outpatient treatment. And then to continue, unless it's not feasible or contraindicated, the psychologist shall discuss confidentiality at the outset of the relationship and throughout the relationship as new circumstances warrant. Okay, so a lot of attention and a lot of specifics devoted to informed consent as it relates to notifying people about confidentiality and its limitations. So, we want to be thinking about, what are we obligated to tell these examinees up front about how the information will be used, who will be privy to it or access, who will be able to access it, etc. Go to the next slide. I was surprised when I found this discussion in the Psychology Practice Act that talks about confidentiality, but confidentiality specifically in the context of forensic, court-ordered, and child custody evaluations. That's the language that's in the statute. This is verbatim. Again, emphasis added by the italics by me. The psychologist shall explain the limits of confidentiality to parties at the outset before the evaluation begins, and the explanation should be documented. So how are we documenting that examination? Some people use forms. There's no obligation to use forms. There's other ways to document that this has been explained, independent of forms. Maybe you prefer a form. The psychologist shall also clarify how the information will be used, and which parties or entities will have access to the evaluation, and the procedures of the evaluation, the purpose should be described to the parties. So a lot of language regarding the content of the disclosure. And then there's specific reference to child custody evaluations, which we don't need to talk about as a group. Go to the next page. Okay. Well, what about disclosures of confidential information? Okay, so that's the general confidentiality notification. What about disclosures? We're still in the Psychology Practice Act. Okay. A psychologist may disclose confidential information without informed written consent when the psychologist judges that disclosure is necessary to protect against a substantial and imminent risk of serious harm being inflicted by the patient on self or a third party, another person. In such cases, the psychologist shall limit disclosure of the otherwise confidential information to only those persons and only that content necessary to address the imminent risk. So that might be law enforcement. It might be a treating entity. It might be the intended victim. I'm going to go home and harm my wife, my spouse. And then, of course, not only are the parties who hear about or get access to the confidential information, not only is that limited, but what information is shared itself is limited. I'll point out that I was a little surprised to see the language of may disclose confidential information, not a must or will disclose confidential information, which I read as permissive, not mandatory. I'm sort of sensitive to that. I practiced in Florida for 35 years. For the longest time in Florida, it was similar. Florida used similar language that healthcare professionals generally were permitted to share confidential information when concerns came about risk to patients or third parties. It was not mandatory. The law in Florida changed just a few years ago with the shooting at the Fort Lauderdale school. A young man, 18 years of age, went to his old high school, killed about 17 students, and I think a school teacher. And a later inquiry suggested that there were a number of healthcare professionals who had knowledge of some of this young man's threatening ideation or violent ideation, but made no disclosure. They revised Florida code to make it a mandatory breach of confidentiality when it was permissive previous to that. Okay. Jason will get to that comment. Let me just sort of get through a thing or two here. Let's go to the next slide. Release of confidential information. Again, we're still in the Psychology Practice Act. The psychologist may release confidential information upon court order or to conform to state or federal law, rules, or regulations. So this blanket permission, acknowledging court orders are legitimate to release confidential information. Again, it's may, not must. Or if there's other state or federal law, rules, or regulations that presumably aren't referenced otherwise. But imposing upon the psychologist the obligation to consult with others and take appropriate action if a court order appears to violate confidentiality rights under state or federal law, rules, or regulations. So sort of it gives and takes away in some way. All right, let's go to the next slide. Okay, so Jason, Anita, can you repeat Jason's query that he just posted or comment?
Oh, certainly. In the scenario where an expert is a court-appointed expert and the client is effectively the court, how does it change how the defendant has access to the report? In other words, is the contracting agency or the court themselves the custodian of the record, considering that the report might be sealed by the court from a New Mexico standpoint, of course.
Okay. Great question. I think it's a complicated matter. I think we have to consider, among other things, federal law, including HIPAA, because generally that law grants people grand access to records, healthcare records. There were initially arguments that records of and reports summarizing forensic examinations were not governed by HIPAA. Some of those arguments were made by some. There were others who were arguing that no, HIPAA did apply. And I can not say, I really don't feel comfortable saying more than that. I would love to hear from an attorney familiar with New Mexico law about how they treat that. But in my experience, litigants have been very successful in getting their hands on reports summarizing evaluations of their functioning, either on the grounds that it's healthcare records or on the grounds that, well, it's relevant to the litigation. And I'm the subject of the litigation, in this case, the criminal defendant. And why am I not privy to it? Having just finished my first year anniversary here in New Mexico, I can't speak to any New Mexico specific twists on that analysis, but I appreciate the question for sure, and would love to hear what an attorney has to say about this, and encouraging to hear that we might get just that. Okay. Privilege. Okay, a lot of people get these two concepts confused. This is a dictionary definition of privilege: a legal obligation to protect certain communications, including confidential ones, from being revealed in a legal proceeding without the consent or over the objection of the person who holds the privilege. Okay, and we're all familiar with different kinds of privileges. Everyone's heard of the attorney-client privilege, right? What you tell your attorney can't be revealed in a legal proceeding over your objection or without your consent. I know some jurisdictions have an accountant-client privilege. There's the spousal privilege, what you share. Your spouse cannot be forced to share communications from you over their objection or without their consent. By the way, they're certainly capable of sharing what you shared with them over your objection. For example, just among other reasons, to facilitate prosecutions in intimate personal violence cases. You could imagine how defendants, offenders could protect themselves by muzzling the victims of their crimes in terms of what they could, communications they could or couldn't recount. So the spouses, my understanding of the laws and non-lawyers, the spouse is always free to share the information if they're so motivated. Psychotherapist patient privilege, which we have in New Mexico, and the priest penitent privilege, right, which is what you share to it's not simply limited to priests, which has some sort of a specific religion connotation, but religious figures who might be your counselors or provide you guidance on what you share with them. In some jurisdictions can't be revealed without the privilege holders' consent or over their objection. I think the two privileges we'll be talking about this afternoon briefly include the attorney-client privilege and the psychotherapist patient privilege. So let's go to the next slide. So we're in New Mexico rules of evidence. Rules of evidence. And that's where you typically see reference to privilege, because the rules of evidence are all about what evidence gets in and is shared in a legal proceeding, and the privilege information might be information that otherwise doesn't get into evidence because of the presence of the privilege. So in New Mexico, a patient has a privilege to refuse to disclose or to prevent any other person, like your psychotherapist or your physician, from disclosing a confidential communication made for the purpose of diagnosis or treatment of the patient's physical, mental, or emotional condition, including drug addiction, between the patient and the patient's physician, psychotherapist, or state or nationally licensed mental health therapist. I've never heard of a nationally licensed mental health therapist. I've heard of state licensed mental health professionals. I don't understand the redundancy of psychotherapist, but clearly this is going to apply to, I think, essentially any mental health professional, right, who might be attending this training. Okay, so there is this psychotherapist patient privilege. Let's go to the next slide. But there's always exceptions, right? And these exceptions are very, very common, okay? Proceedings for hospitalization, all right? So you might initially think, well, what's that all about? If there was not such an exception, a patient who did not want to be hospitalized, who wanted to frustrate involuntary hospitalization, could prevent his or her treatment provider from testifying at the hospitalization proceeding, simply citing psychotherapist patient privilege. And it is the psychotherapist himself or herself who might have information very relevant to informing the decision maker's decision about whether the person meets criteria for involuntary hospitalization. So absent this exception, a lot of involuntary hospitalization proceedings could be frustrated, but there's this exception. By order of the court, unless the court orders otherwise, any communications made by an individual during an examination of that individual's physical, mental, or emotional condition that has been ordered by the court are not privileged. And I always refer to this as an exception, as a common sense exception. How could you give the court the authority to order an examination and then give the subject of the examination the authority or power to preclude the results of the examination being shared? That just wouldn't really make sense, I don't think. So court-ordered examinations, start thinking competence examinations. Here's another exception to the privilege argument. I'll also point out that in the court-ordered competence examination, no one's doing psychotherapy. None of us should be thinking about ourselves as a psychotherapist. Even though we might do it in another context, none of us should be thinking about ourselves as psychotherapists when we're evaluating criminal defendants around issues of competence. And this specifically applies to psychotherapist-patient privilege. Let's go to the next exception. Elements of a claim or defense. If a patient relies on a physical, mental, or emotional condition as part of a claim or defense, think, I did it, but I was insane. Think, yeah, I'm impaired in such a way that I can't move forward with the legal process and get a fair trial. No privilege shall apply concerning confidential communications made relevant to that condition. After a patient's death, if anyone wants to rely on the person's condition as part of a claim or defense, no privilege shall apply for confidential communications made relevant to that condition. So what does that mean? That means if someone is going, if the individual himself or herself, the privilege holder, is going to breach the issue. I'm incompetent because I have a severe and persistent mental illness. I wasn't of my right mind at the time of the offense, and I'm seeking to be adjudicated not guilty by reason of insanity because of my severe and persistent mental illness. They can't claim what would otherwise fall under the psychotherapist patient privilege as privilege. There's an exception to that. And then finally, an exception regarding obligations to share confidential information otherwise. No privilege shall apply for confidential communications concerning any material that a physician, psychotherapist, state or nationally licensed mental health therapist or patient is required by law to report to a public employee or public agency. So start thinking about the exceptions by way of risk of harm to self or others, or reasonably suspected abuse, neglect, exploitation of someone who falls into that protected category: children, vulnerable adults, etc. So let's go to the next slide. So let's spend a little time talking about mandated reporting more specifically. And I'm starting with adults. You might think I'd start with children, but I talked about in the language here in New Mexico is incapacitated adults, at least by the statute title. Any person having reasonable cause to believe that an incapacitated adult is being abused, neglected, or exploited shall immediately report that information to the department. The report can be made orally or in writing. The report shall include the name, age, and address of the adult who's the subject of the report, the name and address of any person responsible for the adult's care, the nature and extent of the adult's condition, and how the reporter knows. I'm her neighbor. I saw her abused. I'm her treating social worker. She shared with me abuse at the hands of her caretaker or whatever else. Next slide. Next slide. There we go. It is a crime not to meet your reporting requirements when it comes to incapacitated adults. It's a misdemeanor, and it also can be sanctioned with a financial penalty as well. So there's the cost for not reporting reasonably suspected abuse, neglect, exploitation of an incapacitated adult. Go to the next slide. Well, you know, the devil's always in the details. What do we mean by incapacitated adult? In New Mexico, it's any adult with a mental, physical, or developmental condition that substantially impairs the adult's ability to provide adequately for the adult's own care or protection. So you can imagine someone with an intellectual disability, a developmental condition where it might limit their ability to provide adequately for their own care, protect themselves or care for themselves. You can think of a variety of mental conditions that might limit ability to protect and care for oneself. Can you even imagine physical conditions? There might be no related effect on psychological or cognitive functioning, but just their physical limitations might make them dependent or unable to care or protect themselves. And then there's specific language devoted to abuse and neglect and exploitation. I'm not going to read through these definitions, but let you know that they are available in the content specifically for later reference. But I really don't see the value of going through the definitions. Just want to sort of alert you to their presence. Go to the next slide. Okay. Here's exploitation as well. I will point out that, in my experience, exploitation often involves matters of economics, right? So you might come to learn that a family member, as you understand it, is exploiting the vulnerable adult financially. In one way or the other. Spent 35 years practicing in Florida. Florida is pretty progressive when it comes to protecting older people who are disproportionately represented in the vulnerable adult category, for sure, as a result of all the physical and mental conditions that you're more likely to experience as a function of aging. And Florida's pretty good when it comes to protecting all vulnerable adults, including, older or vulnerable adults who maybe their vulnerabilities can in some way be attributed to aging. But obviously not all adults need to be old or older. As a function of the nature of the condition that's impairing and makes them vulnerable. Here's the definition of neglect again, but we don't need to go through it. Go to the next slide. There is good faith protection, which is always reassuring. That, for example, if any of us make a report we're immune from civil or criminal reliability unless we acted in bad faith or with a malicious purpose, which you're never going to find protection for bad faith acts, or you're never going to find immunity for bad faith reporting, bad faith acts, or malicious reporting or malicious acts. But that's always good to see, obviously. Let's go to the next slide. Okay, now we're moving on to children. Okay, covered adults and that reporting requirement. Now we're talking about minors. Every person, and then there's a whole list of people who knows or has a reasonable suspicion that a child is abused or neglected, shall report the matter immediately to local law enforcement agency, the department, or tribal law enforcement or social services agency for any Indian child residing in Indian country. A lot of people don't know that a lot of people don't realize that the abuse, neglect reporting requirements for both vulnerable adults and children are universal to everyone. Right? You have reasonable cause to suspect. You're a janitor, and you have reasonable cause to suspect that the parents in the apartment next door are abusing their child. We have an obligation a legal obligation in New Mexico to report that. You work in the cafeteria at the nursing home. You have reason to believe that one of the residents is being financially exploited by a staff person. You have an obligation as a function of being a citizen of New Mexico or anyone, not as a function of your employ. So it is everyone. Okay. All right. Not attorneys, though. You see the language here, who has information that is not privileged as a matter of law. So let's see, every person, including a licensed physician, a resident or an intern, examining, attending, or treating a child, a law enforcement officer, a judge presiding during a proceeding, a registered nurse, a visiting nurse, a school employee, social worker acting in official capacity, or a member of the clergy who has information that is not privileged as a matter of law, who knows or has a reasonable suspicion that a child is an abused or neglected child, shall report the matter immediately to. So I'll just be straight with you about this. I was just reading this definition, and I saw this, or a member of the clergy who has information that is not privileged as a matter of law. And I did not recognize that language previously. It's hard for me to believe that that's written so that the psychotherapist patient privilege precludes an obligation to report suspected child abuse. Hard for me to believe that's what that means. Or is that privilege qualifier referring to the clergy? I'm puzzled by that. It's hard for me to believe that there'd be a law in New Mexico that said if you learned of child abuse during the course of providing psychotherapy, you're not obligated to report that suspected child abuse because a privilege excludes you from reporting. But we'll have to give that more consideration. Happy to hear how people make sense of that as well. Let's go to the next slide. Again, definition of abuse is included in the statute. We'll also see neglect coming up here, I think. We go to the next slide. Okay, sexual abuse, sexual exploitation. I think neglect will come up. Some abandonment, maybe neglect's coming next. Okay, here's neglect. Okay, and then we can go to the next slide. Okay, more definitions of abuse. Abuse is distinguished from an abused child. Next slide. Okay, similarly, there's reporter protections. So good faith reporters are immune from liability for reports. Anyone reporting an instance of alleged child neglect or abuse or participating in a judicial proceeding is presumed to be acting in good faith and shall be immune from criminal or civil liability that might otherwise be incurred or imposed, unless, of course, bad faith or malicious purpose. Go to the next slide. Related matters, we actually covered a little of this morning. We have this duty as examiners by way of New Mexico statute to exclude from reports certain information gained from the examinee during the competence examination, specifically information that's potentially self-incriminating. Just to reiterate, that comes from a Supreme Court case that applies in all 50 jurisdictions, Estelle versus Smith, and it applies to, it also applies to language in New Mexico law as well that talks about what is not included in reports, including statements the defendant makes during the course of a court-ordered competence examination that are potentially self-incriminating. And there's even a solution for that, that information is to be redacted from the report if the examiners missed it or is not paying attention, or is not aware of that section of the code. I hope we all are, but if there's some kind of oversight maybe in that way. Go to the next slide. So what are some key points? The New Mexico Psychology Practice Act permits psychologists to breach confidentiality to comply with state and federal law. It does impose upon them an obligation to make sure that any kinds of requests or demand, are lawful, okay? The New Mexico Psychology Practice Act permits psychologists to breach confidentiality in order to protect clients and third parties from harm, with the caveat being that the way the psychologist breaches must be limited in two ways: who is notified, and then what information is shared. And in both cases, it's only people who need to know are notified, and then only information that's relevant to the issue is to be shared, not ancillary stuff or stuff that's irrelevant. New Mexico law requires healthcare professionals and others to report suspected abuse, neglect, exploitation of vulnerable adults and children. Next slide. Examinations of criminal defendants that are ordered by the court require that examiners provide explicit instruction about the absence of confidentiality, the absence of privilege, consistent with both APA mandates and also consistent with Psychology Practice Act mandates. We went through that in considerable detail. In my experience, some attorneys will claim if you're not carrying out an evaluation ordered by the court, conducted on behalf of and for the court, some attorneys, typically criminal defense attorneys, will claim that when retained by defense attorneys, examiners fall under the umbrella of the attorney-client privilege, such that they should not comply with general reporting requirements. Other attorneys will argue that examiners still need to meet these reporting obligations. For example, I've never met a prosecutor who argued that the attorney-client privilege that criminal defendants employ, benefit from or enjoy, not employ, that attorney-client privilege that criminal defendants enjoy precludes defense attorney retained experts, precludes them from meeting otherwise statutorily identified reporting requirements. But I know I've discussed this issue with rooms full of defense attorneys who were adamant that examiners should not make reports in such circumstances. I would suggest that if you are working privately for criminal defense attorneys, you get some clarity on that issue. And depending on how you're going to interpret this, that those attorneys be aware of that. And similarly, defendants you examine be aware of that as well. Go to the next slide. Given the Psychology Practice Act obligations to inform clients and forensic examinees about the nature and purposes of services, a prudent course of action is to make sure examinees are provided with information about who will get access to the report, what might be included in the report, how that information could be used, not only to inform opinions about whether someone's competent or incompetent, but also with changes in the law, informing informing the courts about matters of commitment and AOT eligibility and affirmative reporting duties and to whom reports will be made. So I think to take a notification that includes all of this is going to provide, one, not only maximal protection to the examiner, but also maximal protection to the defendant himself or herself, which, he or she is entitled to. And let's go to the next slide. All right. Questions or discussion? Anita, did we get any comments or
There were
questions?
a number of comments. I'll focus now on the last one here, is that I have noticed on the motion for competency evaluation that defense attorneys commonly include vague boilerplate language about why they're requesting a competency exam and cite privilege.
Oh, okay. I want to make sure I understood it correctly. They noticed that defense attorneys whose communications with their clients are privileged, what they will sometimes do is share information, maybe that the examinee relayed to them, that form the basis for the request for the examination. Did I understand that, Anita, correctly?
I'll defer to the doctor who stated that. It looks like it was a common, and I would interpret it in that same way, but
I can unmute if that's helpful.
Please unmute and share your comment. Go ahead,
Sure.
Please.
Hi, Randy. So what I meant was, when we receive the motion for competency evaluation, it will include a little portion in which a defense attorney can indicate why they are requesting the evaluation. I have found, in the less than a year that I've been doing these in New Mexico, that there typically is not a specific reason why they're requesting. So they'll either leave it blank, or the defense attorney will include a very vague kind of boilerplate type of language of the defendant did not demonstrate a factual or rational understanding and communication, but then they will cite attorney-client privilege as the rationale for why they are not including more specific information, which is effectively useless for us as evaluators.
Yeah. So I'll give you a somewhat extended response. And so coming here from, I practiced 35 years in Florida, and in just sort of compare and contrast, in Florida, when an attorney petitioned the judge to order an examination, the attorney was required to identify the basis for the request. By law, was required to identify the basis for the request, but then the caveat was, providing that it did not threaten matters of attorney-client privilege. So rarely, if ever, did examiners in Florida get any kind of meaningful description of the attorney's observations or concerns that made them say, hey, this guy might be incompetent. Could we get a mental health professional to take a look? I've had attorneys provide very detailed responses. And what was clear to me is that nothing in their detailed responses compromised their client's case. My client is all over the board when I meet with him and doesn't appear to understand the most basic things, like he's at risk for going to prison for 10 years, et cetera, et cetera. I don't know, I got to acknowledge, I don't know the ins and outs of attorney-client privilege. And if an attorney shares this much of what her client told her, does that threaten the whole privilege? I don't know about that. When I was in Florida, and I did reach out to attorneys to find out about the basis for the referral, in many cases, their concerns about, well, Dr. Otto, there's attorney-client privilege, I found that they could be allayed when I said, look, I'm just trying to make sure I don't miss anything here. And if you think about that example I gave in our earlier session, where the defense attorney who called me up said she wanted to hire me and said, look, I want to tell you some of the things that my client told me that revealed a level of impairment that other doctor missed. Was she breaching attorney-client privilege? I don't know. I'll leave that to the attorneys. But clearly she was not, whatever she shared with me wasn't, I don't think in any way could be considered to be compromising her client's representation or, standing in any way, unless there's things about attorney-client privilege that I just don't understand, and maybe there are. So I love it when attorneys give us some guidance. I always tell attorneys, the more information you provide, the better evaluation you're probably going to get. That's my take there. Any other comments, questions, issues? We've got plenty of time.
The you were talking about the comment about clergy. So the legally protected thing with clergy is confessions. So it's a universal, New Mexico is a universal state. If you see it, you report it. If you observe it, you report it. The only thing that's protected by law is like confessions or spiritual counseling. And that can be.
You think that language is specific to clergy, does not
Yes.
apply to any other privilege?
No.
Okay. Yeah.
I just had a
I'd be
case
surprised.
that this came into question. So
yeah, I'd be surprised if there would be this belief that social workers and professional counselors and psychologists and psychiatrists don't report reasonably suspected abuse because of the privilege. I'd find that very surprising. But yeah, okay. Other questions or comments? Please feel free to unmute. Okay. Nothing else. I'm going to give it back to Alex to remind everyone about the evaluations and continuing education as well. Alex?
Awesome. Thanks, Randy. And before I jump in, Anthony, did you have something you wanted to say?
I think is my microphone working now?
It sounds good. Yep.
Okay, great. I was going to ask Randy, what's your understanding of reporting obligations in situations where you are informed about abuse as a child, but the person is not currently a child right now? Because in some jurisdictions, they'll say like, you're evaluating a defendant who's 19, they report abuse at 17. There's a statute where you would be obligated to report that. How does that apply in New Mexico?
I'm still learning about New Mexico. As I was reviewing that section of the code, I didn't see any direction there with respect to, well, they're an adult and it happened when they were 14 or whatever else. I have yet during my year in New Mexico to have to report reasonably suspected abuse, neglect, or exploitation of a child or vulnerable adult. I have made such reports in other jurisdictions, specifically Florida. I hope that New Mexico functions like Florida insofar as the agencies to which you made these reports, typically by way of a 1-800 number in Florida, the agency to which you made the report was very, very helpful in terms of educating the reporter, me, as to whether my case met the criteria. Right? No, Dr. Otto, we don't take those reports because, or yes, you do have a duty to report this and we need to continue on. So I got great direction from the agency that took the reports into clarity with respect to exactly what and when there needed to be a report made. And I would hope that you and anyone else could get similar direction from that agency, the respective agencies when it comes to adults, vulnerable adults, and children. But I was very encouraged by how good a job they did. That being said, I always coached my students in Florida that if you did reach out, I just got done evaluating a defendant and this is what he told me. In an abundance of caution, I'm calling up because it may meet child abuse reporting requirements. Oh no, Dr. Otto, that doesn't meet the requirements. In an abundance of caution, in that record, I documented that phone call, and I documented the agency representative to whom I made the report, who I only got a number for. You know, they didn't identify themselves as this is Anthony Perillo with Department of Children and Families, Child Protective Services. It was, this is Agent 77 with Child Protective Services. How can I be of assistance today? So in those few cases where I was directed that this doesn't necessitate a report, so we're not taking it, I documented that, you know, on May 15th at 12:40 p.m., I called Child Protective Services, laid out the facts of this case, and was informed by Agent 77 that it did not meet report recording requirements in the state of Florida. So, and I would suggest that anytime we do that, we document that. I see hands of frustration going up from Kim Freeland. Kim, what am I saying wrong? You can unmute if you want to participate, or maybe you don't want to participate. Okay. This is a question for Alex. I just want to make sure we're supposed to complete both CE surveys today. I looked at
Yeah, thanks, Randy. So I just put the CE survey link in the chat. That's the only survey you'll be filling out today. The next one will be available on the 29th. So you'll attend that day to be eligible for that survey. But I did put the one in the link for today. So go ahead and open that one up or complete it in the next 48 hours. Thanks, everybody.
Okay. All right. Sorry about that confusion. Anyone else with questions or comments?
Comment. In a previous life, I was a child abuse investigator, and it's imminent harm. So we will take reports of imminent harm. So past reports, that goes to civil or whatever custody situation is going on, but imminent harm is what is reportable. And that's across the investigators that I've met here, they have agreed.
There has to be imminent harm in order to necessitate the mandatory reporting.
So no, the mandatory report, like he said that when they were a child, but they're no longer a child.
Oh.
So when he's reporting, if there's imminent harm, there's so many things that is imminent harm. So if that individual is with small children, and they're concerned about those small children because they were abused, that's imminent harm. Does that make sense?
And would a reporter get that kind of guidance from the
They should.
the agency?
They should.
Well, that would be good.
Yeah. These investigators have a caseload of 70 to 80 people, so they should get that level of guidance, but sometimes it's not there.
The people we're reporting to, are they actually investigators, or they're sort of manning the
I believe that you get the report didn't come to us. We got the report from the general.
Yeah.
We would get notified of the report and then go out and do the investigation.
Yeah. So the people, I'm just for my own education here, the people taking the reports, are not the people carrying out the investigations?
Sometimes, because I had mandatory times where I had to take calls.
Oh, okay. More
So
offense.
it's a rolling, but we're all trained. The people that take those dispatch are all trained with the investigators as well. That's
Oh.
and I believe that to be the case here in New Mexico. That's what I've been told, that it is very similar in training. But
Okay.
if anybody knows different, please speak up.
Yeah.
If I could build on that a little bit, there have been some recent changes in our children's department, and actually there is a central intake, and so reports are moved through there and then dispersed accordingly. So it is a separate unit that takes the reports, processes them, makes sure they meet guidelines, and then disperse them out.
My approach has always been that it's better to be overcautious than not. And again, I was always very comforted by, I would say, and reassured by the direction I got from those to whom I made the reports in terms of providing me with guidance and as to what did or didn't need to play out. And was never, I never got direction that I thought was just so different that I thought it was, that I would question it. I was reassured by those efforts when I did reach out to them, because there were such concerns. Any other comments or questions before I turn it over to Anita Mesa to see if she has anything she wants to share with the group of us?
No, other than a huge thank you all very much. But I really appreciate it. I appreciate the work you do ongoing throughout the year and taking the time today. And thank you, Dr. Otto, for the presentation.
Okay, I appreciate everyone's participation. And like I said, if you are interested in getting the PowerPoint files that are the most up to date, simply just drop me an email, raotto@salud.unm.edu. I guess I can put that in the chat. How about that? Happy to get it to you. Either I'll get it to you or I'll make sure you get it one way or the other. So